Yeah, my lord, this is the co-accused bail application listed tomorrow before your lordship. And this is the co-accused application. Yesterday.
May it please, your lordship, I beg to mention item number 11, my lord. I may be allowed to withdraw this application.
Item number 11.
11.
It's a AB.
AB, my lord. No impediment.
It is a lot.
It may be sent.
Yes, CD may be sent back. Or Mr. Yu Khan Kuridiba disposed of on withdrawal. He got arrested or what? You have other instructions. Okay.
May I please, Your Lordship? Your Lordship, item number 23, Your Lordship, I have filed one additional affidavit, Your Lordship.
Item number 23.
20.
You have already filed
Yes, Your Lordship. That may be called for you.
item 23. Okay, we are calling.
May I please, Your Lordship? Lordship, I filed an IA criminal for correction of order amendment yesterday. But I have been taken today unlisted legal. Correction of order amendment.
Today unlisted. Little bit Adi Pari was on like Kali Puri. What's of hearing? Today
Only
maybe.
correction.
Also. Yes, sir.
I know.
May it please.
Yes.
My lord, in regard to item 6,
Yes, item
my
6.
lord, I doubt whether your lordship will take it because the first bail application which was rejected, it was by Honorable Justice Nyamar Pathak.
Oh, cha. Okay,
So
then.
possibly
Appropriate bench.
The roster is already there,
Yes, yes.
so possibly it should go there.
Yes, yes. Otherwise, also, if rejected question of rejection is there, then definitely it should go.
Yes.
Allow, now we are looking always allow permutation, but the
Right, okay.
rejection is item number 6, na?
Item 6. And another thing, my lord,
Before appropriate bench.
my lord, can your lordship, I have another prayer in regard to this. So far, arrest memo and all that, certified copy, my lord, we are required to affix it in the court's copy, but wrongly it is in my copy. Can we change it?
Can it be? And you want to tag the certified
Yes,
copies in
right.
your copy.
Yeah,
But if you produce the certified copy during the hearing of the course of the hearing also,
I think that
it will
will
do.
also-
Yes, that will do.
All
Because
right.
we are also accepting, because
Right.
there are some copies, the certified copies were subsequently obtained by you.
Right.
So that can be, that
All right.
can. Okay.
My lord, can it be when? Monday, no?
Monday. What is it? Monday? Item 6. Okay, Monday. We are listening to
Okay.
Monday. Monday is 19. No?
Hey, please, Lordship, I beg to mention item number 26, Lordship. CD is not there, Lordship. I am on intent. I am on
26.
intent, Lordship.
CD not received? You are on interim?
Yes.
CD not received, issue reminder. Interim be extended till next date of listing. Yes, when it can be, thus
30 of May.
30. 30.
Yeah, please, Lordship. I beg to mention item number 30, Lordship.
30.
Yes,
Yes.
the matter may be adjourned for the day, Lordship.
CJ is it also.
So you are going to retain the case diary?
CJ said that. Or.
You are on interim there?
No,
You are not, she is not on interim, so let it be on 35. 30. Okay.
Then
Ish.
by the city law.
CD be retained. CD be retained till next date of listing 35 at a request made by so superior.
I'm on behalf of Escort. My name is not
You are
written.
behalf of on
Yes.
escort.
My name is- Hi, Lordship.
Lordship, I am seeking posting, Your Lordship, of the matter, Your Lordship. This is criminal rate petition, Your Lordship. Last, it was listed on 14/2/2025.
Hmm.
So I'm praying for listing this matter, Your Lordship, on 22.
22.
Two.
27. Okay. All right.
Wait, please, your lordship. Lordship, I beg to mention item number 34 to 36, my lord. My lord, criminal appeals, my lord. Connected matters, all three. My lord, these matters have been part heard by Honorable Justice Mr. A.D. Chaudhary. The order dated 21/11/24 reflects the same. After that also it has come up before Honorable Justice on 2-3 occasions. Today possibly wrongly listed before this court. Maybe
Is
past
there any
couple-
order of part heard and all? No.
Part heard, yes, your lordship. 21/11 order reflects it. And after that, it has come again before Justice Chaudhary only.
34 to
36, my lord.
34 to 36.
34 to 36, my lord. I am in item number 36, but I've already informed them with the consent of all the parties for item number 34 and 35. I'm making this mention before your lordship.
Okay. I will take AD Chaudhary. This is AD Chaudhary.
Added some line.
Oh, hardest some line. Okay, then.
There is there, my lord. So appropriate orders may be passed, my lord, and list before the appropriate bench.
Yes, before the
Obliged.
appropriate bench. Okay.
34. the bench.
Yes, before appropriate bench. After 1 week, we'll do.
Yes, my lord, any as per the convenience. of the
Because it is
order.
of 2009 matter,
Yes,
so
my
after
lord.
1
Yes,
week,
my
we are
lord.
listing.
After, yeah.
After, as it will be date to be fixed by the
Date
registrar.
will be fixed by the
Okay,
registrar.
okay.
Deeply obliged, my lord.
After 1 week, we'll do.
May I please, your lordship? Your lordship, I beg to
You
mention
take
for
that.
requisition.
Economic or the request made by so and so.
May I please, your lordship? Your lordship, item number 14, I beg to make mention for
40,
your lordship.
14. Yes.
Requisition, your lordship, of an additional affidavit, your lordship, filed
You
today.
have filed an additional.
Indeed.
Okay. In item number 14,
14 indeed.
Respondent lordship, here lordship, CD not received. CD case that this is not a charged matter lordship, CD not received.
so you want CD.
Yes, lordship.
Your lordship.
In that case, it will be adjourned, I think.
Your lordship, when the matter come and serial number 14, your lordship. Same matter.
No, no, yes, she is submitting on that only.
Okay.
We may call your affidavit. That is question is there, but CD she is calling for, insisting on call for the CD.
Lordship, he will join after 20 lordship. This matter will fix on 21st lordship.
21st. Okay, Nico, at a request made by MS. Yes, Deca and Deca, appearing on behalf of Standing Council NCB. Matter may be listed on 21/5/2024.
Your lordship.
Issuing reminder for the CD. Further, considering the submission made by learned counsel for the petitioner, Mr. T. Laskar, let the affidavit be called for, which has already been filed by the petitioner.
Your lordship, based on the affidavit, we have a small submission also, your lordship. That is the.
No, we are not going to.
Please, your lordship, with regard to item 29,
Item
29 lordship.
29.
Yes.
CD not received.
29. Are you in interim there?
Yes, lordship.
You are in interim. CD not received. Issue reminder. Yes.
4th of June, lordship.
4th of June. 4
Yeah.
6. Okay.
May I please, your lordship?
Interim be extended till next date of listing. Yes.
Lordship, beg to mention item number 12, lordship. But if
12.
did not receive, also they have not filed the objection on.
SC customs is there. Yes.
Matter lordship, LCR not received. Lordship, we could not file our objection lordship.
But your custody period where since when he
146 days today, lordship.
146 in a sense it is charge sheeted or not the charge sheeted? CD.
Last the CD was called for.
CD lordship.
CD was called.
Yes, lordship.
CD not received. Issue reminder. Further, the Standing Council Customs is hereby directed to submit to the written objection, if any, on or before the next date of listing.
Which short date may be fixed, lordship. Already 146 days, lordship.
Twenty-six 5. Oh, obliged, lordship.
Yeah, please, your lordship, but I like to mention, an IA for funeral, for listing,
What kind of IA this one?
IA criminal lordship.
IA criminal.
Yes, lordship, as agency is there, lordship, there is a threat of deportation,
Date of?
there is a threat of deportation, lordship. The petitioner are seen refugee from Myanmar, lordship.
Today, tomorrow, it may not be possible, at best Monday. Monday will do it.
It may be late, lordship, kindly allow for tomorrow, lordship.
Tomorrow, not possible. We have some other reasons. We are not listing any matter tomorrow. Except some things, but otherwise it will be Monday. Monday.
May I please, your lordship, I beg to mention item number 27.
27.
27, kindly adjourn the matter for the day lordship.
27, what is the position does? 27. Scan copy is received. Are you on, is there any interim on your part? No.
No, no.
I think. At a request made by the learned counsel for the petition, matter is adjourned. 26/5. After 1 week. Yes, this after 1 week. Okay. After.
Deeply obliged.
May I please, your lordship? Lordship, in item number 44, the matter we taken to adjourn for today, your lordship, because in this matter, minimum Mr. PN Gusam is there. He is not the additional AG and the Standing Council Forest Department, lordship. So may I pray the matter be adjourned for today, Your Lord?
44,
41,
41.
41.
B Sharma is there, I think.
B.
maybe.
Sharma is there, but then even name of the PN Goswami is there, the petitioner side, Your Lordship. He is a special PP for the
PN Goswami.
PN Goswami is there, Your Lordship. His name is there.
Now what is your submission?
Submission said, let the matter be adjourned for today.
So you are appearing for
Mr.
Mr. PN Goswami.
Yes, Your Lordship. On behalf of PN Goswami.
But name of Mr. A.M. Bora is also
A.M.
there.
Bora is also there. Even Mr. PN Goswami is there. So let the matter be adjourned for today. Let the matter be clear.
At the request made by so and so, appearing on behalf of Mr. Your good name?
R.R. Gogoi.
R.R. Gogoi, appearing on behalf of Mr. P.N. Goswami, wait for an adjournment. It's the matter accordingly. After 2 weeks, we'll do. After 2 weeks.
Obliged, Lord.
Arrested on 21/3/2024.
No, motion, we are not going to hear. What is we needed here? List?
Item 1.
No, yes. Here is a charge sheeted case or not yet? Charge sheeted case? Then we'll call for the, because we are facing some problems, so we are not going to hear the matter at the motion stage itself. So we are listing it on at best 23 or 20. He is in custody since one,
Since my lord, 21/3/2024. 1 year,
21,
1 month,
1 year less.
more than 1 year.
Yes, 23rd. We are calling for the case record, scan copy of the case record along with the case diary.
Otherwise, my lord, original certified copy. is-
No, we are not going to hear. We have some problem with that. 23rd, we do, 23rd of May. Registry will do the needful. Call for the case record. Okay.
Obliged.
And if you have the certified copy, furnish before us on that day. Next date of
On that
listing.
day,
we
my
will-
May I please, Your Lordship? In item 10, in same case, CD has been, Your Lord.
CD
Already.
received already.
Yeah, already in item 10, same case.
Item
Lord-
10 CD already received.
Yes,
Acha.
Your Lordship, the petitioner was arrested on 22/6/2022.
So
that
item
is-
10 is also you are appearing?
Yes,
No, in item 10 you are appearing
yes.
in both 2 and 10.
Hmm.
Okay.
He was arrested on 22/6/2022.
22,
Yes.
6, 22.
That is more than 2 years, 10 months. Your Lordship, on the length of detention, there is Supreme Court order as well as.
And what
by
is the
your
stage of the
lordship,
case? What is the
out
status of the
Out of
case?
11 witnesses, only 2 has been examined.
11 witnesses,
2 has been examined.
2 examined.
2 examined.
Hmm.
So I'm saying on the length of detention, Your Lordship. We forgot, and Your Lordship already also there.
So basically you are on the length of detention or in long incarceration. Here you have filed in item 10, you have filed the objection here.
Lordship, I would not file an objection, but Lordship, I will do this matter today.
Already
Lordship.
5 months.
Lordship, here, Lordship, final complaint has not been annexed. So Lordship, allow me some time to go through the record, Lordship.
You have not annexed here the final complaint?
Item number 10, Lordship.
Final complaint, I mean the charge sheet, whatever.
Charge sheet is not available in the, I applied, but
No, we need the charge. Charge sheet is needed, required.
in item 10, the CD is there, Your Lordship.
Have you gone through? Yeah, in item 10, it says case diary, it's a case.
Lordship, LCR received, Lordship, allow me some time to go through the record, Lordship.
Okay, then, okay. Body matters, the
Lordship.
timing.
At 2, Your Lordship.
Add to Lordship,
2 VC is there.
after some time.
Okay.
After some.
Make us one attempt. If it is not possible, then after 2. But for the timing, we are keeping both.
Okay.
Item 3.
Yes.
Executed quantity, Lordship, only 23 days, Lordship, first week of June, not like that.
Yes, when it can be called for.
Do not, Lordship, not like.
On 5th of June.
5th of June. Okay. CDB call for 5th of June.
Much obliged, Your Lord, much obliged.
Item 4.
Maybe resolution. Commercial quantity arrested on 30/11/24, my lord. Today is 166 days, my lord. Charge sheet-
Here we need CD, I think, na? Charge sheet is already there.
No, my lord, charge sheet not submitted, my lord.
CD is required
CD will be required.
on 4th June, Lordship.
Court will, this time will be not there, Nikki, I think.
166 days.
You are 166 days,
Hello.
then how many days left? 14 days.
My lord.
Lordship on 26.
Yes, 26 can be. We are calling for the case diary on 26th. 26 make it.
Item 5.
May I miss your lordship? Your lordship is a regular bill. Charges are under section 61, clause 2, 123 of BNS and 21A of NDPS lordship. While 123 is non-bailable, the other two is bailable lordship. Lordship, my humble submission, lordship, is to consider this bailable offense separately and grant me bail, lordship. Even if your lordship.
No, as a whole, the case is not bailable, I think. Not bailable.
It's 21.
The sections,
NDPS, small quantity.
till now, we have not considered any sections, even in spite of in a small quantity, it's not considered as a bailable offense because statute itself says these are non-bailable offense. We are not on considering that it's a bailable. Some of the high courts, there are some high courts which where we have seen that it is considered to be bailable, but we are not considering it bailable. Otherwise, 123, what is 123? 123 is
Causing hurt by means of poison with intent to commit an offense, lordship.
It may extend it to 10 years, Lordship.
so it's
We
not
did not.
bailable, I think.
Lordship not bailable.
It's not a case of bailable offense.
This is 123 is not bailable.
Even
Otherwise,
123, 21A, these are also not bailable. 21A, obviously, for instance, for consumption, it may be considered. Otherwise, your petitioner is in custody since when?
5th of March, 5th of this month, lordship.
5
5th of this month,
25,
5.
Yes, lordship.
Then obviously CD will be
CD is
required.
Lordship.
Lordship, to support my case, I've annexed the medical record of my mother, who is an end-stage treatment, who is undergoing end-stage treatment, and my presence is very essential.
Short
To
date may
assist-
be given.
We are
Lordship.
giving you short date, very short
Lordship,
date.
actually, I've rely on one case of this Guwahati High Court, the bail petition, it's in page 8, page 7. Bail petition number, page 7, 7th page.
Page number 7.
Yes, lordship. Bail number, may I read, lordship? Bail number 472 of 2023. Order dated 3/2 of 2023. The Honorable Guwahati High Court held that the offense under section 21A of the NDPS Act is bailable offense.
No, I won't go by this.
Held by,
This is statute, unless there is an order from the Honorable Supreme Court, I won't go by that. That apart, 123 is exclusively non-bailable offense. If you're saying that is a bailable, it cannot be considered as a bailable because punishment is up to 10 years. It's a grievous hurt. So we cannot consider it a bailable offense. As a whole, your petition, entire petition can be considered as a bailable offense. If it could have been bailable offense, then definitely you would have raised the issue before the arresting authority itself. But the question is that we are trying to accommodate you. We're giving you a short date. Next Monday we are giving because tomorrow may not be possible. May not be, no, it's not possible also. Monday, can it be from where? It
From
has to
Karbi
come.
Anglong, Lordship.
Karbi Anglong, Monday may not reach, I think.
Monday is difficult.
Monday is difficult.
On,
Tuesday, either Tuesday, Wednesday.
Next Friday, Lordship, 23rd.
23rd will too long for you?
So
1 week.
1 week, if the city will not come.
It's
we
then
will not
again, same
help.
situation will be there. So Thursday is what?
22nd, Lordship. We
Can it
try-
be on Monday, Tuesday, Wednesday, 23rd, I think? 22. 22nd, we are listing. We are trying to list on 22nd. If it reaches, then well and good. If it is not, then you make your submission, we'll see to it. Okay.
Yeah, no.
So we are listing at present on 22nd and don't think that these are all bailable offenses. These are all non-bailable offenses. I don't know 61, but other one 123 itself is non-bailable
Yes,
offence.
123
So we are
is non-bailable.
listing it on 22nd of May. We are trying to give you a short date. That apart, we don't have any short date.
Okay,
Your
Your Lordship,
Lordship, okay.
compliant.
Okay.
Item 7.
Map eligible. This is LDPS.
You are here, you are NDPS and the grounds of arrest you are taking.
Lordship and I
We are
have
not going to hear the matter. Is the case of charge seated one or not?
charge seated Lordship.
Charge seated. So we are calling for the case record. We are facing some problem. If you go in my visit in my chamber, you will
No.
see what is the condition. So we are not going to hear the matter at the motion stage. We have some problem. We're
Okay.
facing some problem. So we're calling for the case record. In fact, scan copy of the case record. Otherwise, what is your submission? You can these
I have managed the certified copy.
certified copy. You can
Lordship.
the day of hearing itself. You can submit before us. We are not going to hear the matter.
Page number 29, 30 and 31.
Yes,
Lordship.
obviously there may be. I think
Lordship.
the scan copy of the case record along with the
From
city
Guwahati
report.
Lordship. Metro.
From Guwahati Metro.
Kamrup Metro.
27.
Lordship. Can it be Lordship? 22-3 Lordship.
27.5. He is in charge seated case only.
Obliged.
Item 8.
Please, Your Honor. Lordship, this is a NDPS matter. The person was arrested on 29/11/22. He's been in
29, 11.
11/22. He is in custody for 2 years, 5 months, 16 days till date.
Hmm.
Uh,
And what
Your
is the
Lordship,
stage of the case as per you?
it is for evidence stage. It is in the evidence stage.
How many witnesses till now?
Only four witnesses have been
Out of?
examined out of 8.
So obviously there is some progress.
Lordship has already
Scan
given
copies.
three bails to the 3 co-accused. There are 4 accused and 3 of them have been given bail. Lordship,
Considering the what ground, incarceration or
vaccination and
as well as the non-furnishing.
round.
So that's what I'm saying. We are dealing with some cases similar kind of as well as your submission. Other matters are also there. We are not going to hear the matter at the motion stage. We have some personal problem. So we are listing it on yes, 27.5 or 26.5, 26.5. We're calling for the case record.
It is from Kamrup Metro. 22nd, if maybe.
It is
And
second.
LCR is scan copies of LCR are there in the other bail applications also. They are called for.
Can you tell us the other bail
Yes,
application number?
I have already stated in my petition.
Just tell us the numbers.
Bail application number 485/25.
485,
25
25.
and 194/25. Bail application number
Okay, if we add, I mean, tag 1, then it will do. List on 22nd of May, so and so, call for the scan copy of the case record, and the matter may be tagged along with the BA number 485 of 2002. Okay, well, listing it on 22nd.
Item 9.
Yes.
This matter may be taken after some time.
No, after some time we'll do. What is the nature of case? We are not going to hear the motions. That's why. Okay, then we are charge seated case.
Yes,
We are
ma'am.
calling for the case record and scan copy of the case record be called for. From where it has to come?
Sribhumi.
From Shivbhumi. Then 26.5 will do?
6-5 Lordship.
26.5. Well,
I
it's
know.
done.
For bail hearing, item 13.
Thank you.
Petitions are very long.
in this case, my service is awaited, my Foxon matter.
Item number, what item number?
13.
13. Service is still awaited. You have taken steps already? Otherwise, we have received the scan copy.
Yes.
Uh, uh, The last occasion, it was reflected that you have not taken steps, in fact. Subsequently, you took steps, I think. Till next date, can it be abated or what to do? You take instruction on the next date? Your petitioner is in custody, na? We're giving a short date for instructions. On that day itself, we may appoint an amicus also. If appears, all right. If not appear, okay. Pardon?
After a week, 1 week.
Let it be a fixed date also.
Yes,
No,
ma'am.
no issue. You
Yes.
can take instructions.
Sure.
Heard Mr. A.M. Borvian, the counsel for the petitioner, and also heard Mr. M.P. Kuswami, the learned additional PP appearing on behalf of state respondent. Likhok, from the office note dated 8/5/2025, it is seen that the service is still awaited for the respondent number 2. In that context, Mr. Kuswami is hereby asked to take instructions in regards to service of notice on respondent number 2. Scanned copy of the case record has already been received. Full stop. Next date, 20 can be given, short date, okay, 25,
Carry 21, madam.
21.
Apply.
15.
LCR has come, my lord, but we are yet to go through the CD, my lord.
My lord, in this case,
Justice, justice.
Yes, ma'am.
You need some time.
Yes, my lord.
in this case,
Tomorrow we are not listing.
my lord,
We are facing very much problem, in fact, dealing with all these matters. So, because if you go, there are lots of matters yet to be.
can it be a two lordship?
Day after tomorrow is,
Funny, but.
Lordship, they may,
if you take at 2 also, we have some, I have on VC, in fact. Thereafter, if time, VC maybe for 10-15 minutes also, because may not be hearing also. So at 2 can be second half.
second. In the same footing, lordship, co-accused got bail, lordship.
At 2.
Obliged to lordship.
Yes. Okay.
16.
This matter will be taken after something,
Yes,
After some time.
after something.
Otherwise,
We are seeking the bail on the grounds of arrest, non-furnishing of the grounds of arrest.
Now, see, question is that we are hearing the matters that where the grounds of arrest you are taking. Those matters are also considered by the learned trial court below. As case is already charged, we do not want to interfere, in fact. That is the issue. Otherwise, if it would not be searched, definitely it would have been entertained. Yes, yes. Trial court is dealing with these matters. Yes. Charge sheeted case, we do not want to.
In that case, with the observation, your lordship.
Yes, obviously. Okay, what is this charge sheet number?
Seat number 147/25,
Yes,
34/25.
34/25. Your name is here, you're Mr.
H. Lester.
A.H. Laskar. Heard Mr. I.S. Laskar, the learned counsel for the petitioner, and also heard Mr. M.P. Goswami, the learned additional PP appearing on behalf of state respondent. Case was fixed for case diary, but it is submitted by Mr. Goswami. That case has already been charge sheeted by CS number 147 of 2025, dated 34/2025. Full stop. In that context, Mr. Laskar submitted that he has also raised the issue of non-furnishing of ground of arrest to the present petitioner. Full stop. In that context, Mr. Laskar is hereby Mr. Laskar, or the petitioner, is hereby asked to take the plea of non-furnishing of ground of arrest, etc., before the learned trial court below, with an appropriate application for bail, which may be considered in accordance with law.
Hello.
17.
Make please your lordship.
Here we have received this scan copy.
Can copy were received, madam.
Yes.
Your lordship, 483 BN. This is the petitioner was arrested on 14/7/2024, your lordship, under section 21C29.
And charge sheet was filed on 7/1/2025. And in this case, your lordship, there are,
Charge not yet framed.
no, charge has been framed, but the
Not
date,
framed.
no, not framed.
Charge not framed.
Here, your lordship, there are 14 listed witnesses.
Yes, sir, it's charge frame, madam, on
No, charge frame, no,
26/3.
Charge frame, and there are 14 listed witnesses, no, none examined till date. This is the basis. I'm just the facts of the matter, your lordship. Here, your lordship, initially, the police has raided the house of one, Quddus Ali. And in the house of Quddus Ali, these two petitioners, petitioner number 1 and 2, were found in that house, and 13 grams, 13 grams of heroin was recovered in the joint possession as part of FIR. Subsequently, police was led to another house, that is the house of Jahida Khasum, daughter of Quddus Ali, and from there, 1 kg 576 grams of heroin was recovered. This is the allegation, and in this case, your lordship. Now, the joint possession that was shown to the both the petitioners was only 13 grams. But from the house of Jahida Khatun, who is the daughter of Quddus Ali, 1 kg 576 grams of heroin was recovered. And this was clubbed together. And then this was made, your lordship, commercial quantity. So now, your lordship, the main issue is again on the same ground, that is section 50, under section 50, notices have not been served upon both the petitioners. Your lordship. No grounds have been given in the notices to the petition. This is basically in this case.
Yes, Mr.
Hello. That count is taken, madam. And the notices are annexed, madam.
Annex page 54 and 55.
54 and 55.
In fact, even Jahida Khatun has also not been arrested. Only these two persons.
After recovery from Jahida, she was not arrested?
No, it was recovered from the house of Jahida Khatun.
Yes,
She
sir.
was not arrested. And only these two persons were arrested. That too, they were recovered only 13 grams.
And Quddus?
Quddus not arrested.
Page 14 is the madam. The last will find.
Page 14.
14, the male and
Page
female.
17, page 17, madam.
No, page 14 to
Page 17, madam.
the male and female members present in the house of Quddus Ali. That paragraph, my learned friend is.
That is where your lordship will find, madam. The police team who would enter into the search procedure was searched in presence of above named witnesses and then searched the house and carried out by me along with the search team presence of above named witnesses. During search, one maroon colored soap case containing transparent plastic packet filled with suspected brown sugar heroin was found from the possession of Sohidul and Madam
And
Oliullah. Passengers,
Next.
second is Oliullah, which has been kept concealed by them in a plastic polythene under a chair. That is
On weighing, your lordship, next paragraph, on weighing the said recovered suspected urine on the spot on the digital weighing machine in the presence of the above witnesses, the weight was found to be 13 grams. And then the seized packet was marked. So that was first part. Second part, your lordship, during spot, third paragraph, during spot interrogation, after the accused person admitted stockpile of used consignment of contraband and accordingly led to a raid further conducted in the house of the sister Zahida Khan. And there they recovered it. This is the fact. Otherwise, I am basically on the ground of non.
So Jahida should come under 25, I think.
no, but since they have led to the recovery, it will come under constructive position also.
No, her house is, if stock is there in the house, in her house, then
Yes.
25 should have come in fact.
Yes,
Against
that
her.
part, yes, her part, I'm not saying, and I'm saying about these two petitioners. Otherwise, madam, my learned senior can have taken that other ground.
Section 50 grounds now.
Her Mr. Y.S. Manna, the learned counsel for the petition. Same ground, khali okman ekhini likhibo. That only 13 grams of heroin was found from the possession of these two petitioners in the house of one Quddus Ali. And subsequently, 1 kilo 576 gram of heroin was found in the house of one Jahida. But surprisingly said Jahida and Quddus are not yet arrested in connection with this case. The accused petitioners got arrested, Babri Sailova. Was arrested on 14/7/2024. CS submitted 7/1. Charge framed on 26/3. 26/3.
26th.
2025.
And next date is my lord, 7525 for evidence.
Out of 14 witnesses, no witnesses could examine by the prosecution till date. Hekini Argo Summit and differ from the forwarding report. It is seen that there are sufficient implementing materials. Okay. It is from which place?
Page 54 and
Place,
55.
which place?
Place,
54 I have seen.
This is from
Kamrup
your
Metro.
lordship, Kamrup Metro. Additional session judge number 3, Kamrup.
Additional session judge number 3 comes special judge POCSO number 3. One is Sohidul and other one is Aliullah.
Aliullah, man.
It is 15 or 47 BNSs. Not 50, 47 BNSs. Okay.
Oblige,
Please.
18.
But in this case, my lord, I am in interim on 25/4/2025. And in this case, my lord, Kashgari was called for a day.
Again, man, search sheet laid down, man.
You are on interim.
Since 25/4/2025.
Okay, man.
The case is, my lord, in respect of the merit of the case, there is no prima facie case against us.
Where is the interim? It's not.
Okay, man. Search sheet laid down on my lord, 34, number 143.
We were released on bail by order dated 25/4/2025.
Then the case is charge sheeted already.
Already started, my lord. Let him, my lord, approach for a regular bail, my lord. In that case,
Because he is already on interim.
already on interim.
We are extending our interim bill of 25/4/2025 till 15 days. Appear before the learned trial court below with a regular application for that will be considered, I think, because we have already narrated all this. But how case is charged from your submission? It was that there is no, I mean, on your basis of your submission, we have granted you interim because neither the parents nor the any other,
Not the girls, nor.
nor
any
even
relative
they refused to come to. So that was the reason we. But now, how charge sheet was filed then?
Charge sheet is filed, my lord. This is everything by police, even the, what is the frankly speaking, my lord? Police registered the case upon the pressure of some authorities, my lord. This is the fact, in fact. Otherwise, police was not interested to register this file. So police cannot file final report, cannot file. Because the way how the case was registered, then it is a certain that the case will be charged. This is the outcome of the registration of the file. Yes. If your lordship, what I have submitted, the case diary may be called for. Even if your lordship may go to the case diary, if anything found against us, my lord, that may be rejected. That was my submission earlier, but they did not file FIR. They did not submit my lord case diary. Instead, they filed charge sheet. Suddenly, my lord. This is the fact.
Maybe. Because fact you have narrated
Yes.
before us, it's quite.
Yes, my lord. This fact will be, my lord, will be revealed in the case diary, but they did not file the case diary.
Yes, what is the charge sheet number? CS number is
143 dated 34/25.
143 dated 34. 25, ঠিক আছে?
My humble submissions, a little protection will be given while approaching before
That's
the
why
time.
we are extending your interim. We can write no corrosive action, etc. But it's already interim. Yes, yes, obviously there will no harm at all. Yes.
Only his submission that such and such by pressure, everything is his story, my lord. Whether it is believable or not, it will.
Maybe,
it will be the
maybe
trial court,
story
my
may be
lord.
different also.
Story may be different also. my lord.
Yes, okay, but we are extending your petition.
Mine.
Please.
19,
May I please your lordship?
Yes.
I was arrested on 27/10/23. It's been almost 1 year and 6 months. I've been behind bars, your lordship.
27/10/23.
Yes, 27/10/2023,
23.
your lordship.
24.
23.
23.
It's been 507 days to be precise, your lordship. Out of 12 witnesses, none has been examined, your lordship. It is as the state of evidence. Your lordship, it is pertinent to mention that at the time of arrest, though notice under section 50 was served. However, no grounds of arrest were mentioned in the said notice. Your lordship, if you may allow me, I have the full certified copy of the said notice, which my
Yes,
colleague will.
yes.
There is an earlier order in the file.
Yes, your lordship, I rely on the judgments of the Honorable Supreme Court, that is Vihan Kumar versus State of Haryana, and also Pradeep Payasa versus State NCT of Delhi, your lordship. If you allow me, I'll kindly pass you the judgment.
Earlier we received it was not legible.
One order, honorable court's order, whether it is there in the my lord, file. my lord.
Your lordship, if you allow me,
Where is the order? Key question is it?
Court's earlier order regarding co-accused, my lord. Some order is there.
yes, your lordship, the co-accused has been granted bail by this honorable court. I have the orders of the.
Co-accused is Hassan Ali.
Yes, ma'am.
Okay.
So out of 5 accused, your lordship, all 4 has been released. The said petitioner is I'm standing for a said petitioner, your lordship.
Your petitioner's name is?
Augyan Langel, your lordship.
He's from Manipur.
Yes, ma'am.
In your lordship will find in the seizure list, there is number 4.
Is a list.
Yes, and in the FIR also. my lord.
Your lordship, I pray for on the grounds of
Page
parity as well.
21, my lord. Accused number 4.
So recovery was from him.
Recovery from these 4 persons, my lord.
4 person.
In the shopkeeper is my lord Babul Hussain, my lord. And in his shop, my lord, they are all consuming and selling drugs. 5 persons.
Oh, one shop was there, na?
In one shop was there, his shop is my lord on Babul Hussein's shop. That will be clear from the seizure.
One shop, I think.
One shop, my lord,
Yes,
that
ma'am.
will be clear from the seizure list, lordship. In page 28, my lord. Place of seizure.
Mhm. So you are not the shop owner,
No,
but you were there, na?
yes.
Order of the bail application 1323 of 2025. Will be more or less same. He was having, after having namaz asile, he to halai pilai, he was standing outside the pan shop going there. Baki hine ke thaklo. Here also you have taken the ground of non-furnishing. Aro baki same থাকিব 27/1. You also got arrested with on the same day. 27/10/2023. 1 year, 6 months, 12 witnesses, no witnesses. Mr. Goswami. Submission আছে.
And I'm gonna seizure list, my lord. This is from this
Yes.
petitioner, so one of them is his, means my lord, commercial quantity regarding the heroin. My lord.
Contraband they recovered from the conscious possession of the accused petitioner along with some others. And case has already been charged. But he further submitted that from the seizure list as well as from the forwarding report itself, it is seen that the present petitioner is involved in the alleged offense. However, till date, the prosecution could not examine any of the witnesses. Though the charge has already been framed against him, Milady Wahi. Otherwise, rest of the submission 11323 লব দেখিব ইয়াতে লব দেখিব.
There, my lord, there are strict conditions that he is my lord from
He is from
Manipur, my
Manipur.
lord. TOT and my lord bail amount may be increased, my lord.
Yes. Oh. We'll see to it, bail
Sure.
amount and receipt. You have submitted all this?
Yes, ma'am. Yes.
One is Pravirpur Kayasta and others are from the coordinate benches. And one Bihan Kumar. Okay, we'll see. Ground of parity on same ground. This is section 50 CRPC, not 47. This postal. Okay.
Twenty and 21.
In this case, my lord, LCR is received, my lord. And my lord, 3 persons were arrested and one was granted bail by a lordship, my lord. This is the order.
In the next.
One was arrested on suspicion, my lord. Item 21.
No, your petitioner also was, you are appearing for
I am appearing for
one
Jainal Ahmed
Jainal Ahmed,
and Muzakir Hussain.
Muzakir Hussain.
Yes, my lord.
So what is your case now?
Case, my lord, LCR is received and my stand is, my lord, in earlier case, my lord. the petitioner- Same, my lord. Accused number 1, Faisal Rahman, who was granted bail by your lordship, my lord. This is the order, original certificate copies. Seeking bail on same.
No, in other one, he was delivering some raw materials for constructions, but these two, how they are related?
No, my lord, in this case also, my lord, accused number 2 was also, my lord, delivering some raw materials. This is the persons from where the contraband was recovered, that the owner of that house was not made an accused. So
These two petitioners also supplying the raw materials.
one was supplying raw materials and another was nothing is there. He was arrested on suspicion, man.
Only on suspicion.
Only on suspicion, Muzakir Hussain.
No, you are supplying one bail order here,
Yes.
bail application 1401.
Yeah.
Therein you have submitted earlier that he was delivering some raw material
Yes,
for
sir.
constructions
Yes,
of
madam.
building.
I was
But
also.
now these two petitioners I'm asking.
Yes, ma'am. The petitioner number 1 here, my lord. Item number 20, Jainal Ahmed, who is also, my lord, engaged in supplying the raw materials to that house, my lord. And petition number 3, my lord, here, item number 21, he was arrested on suspicion.
Only
That
on
is no,
suspicion.
on suspicion. Everything is an FIR also.
Okay, so we are getting about
He was arrested
21
later.
suspicion and 22 same with bail application number 1401. Okay.
Otherwise, LCR is also received.
Pardon?
LCR is also received here.
Otherwise, what is this says is it was passed on for 5/5. Now today is
Today is, my lord,
15/5.
15.
So any other
No, my lord.
changes?
No, my lord. Nothing progress, my lord.
No other progress.
No other progress. Publish.
Okay, Mr. Goswami, it could be ground of clarity is also there. Ground of clarity could be given.
Twenty-two.
Wait, please, your lordship. In this case, the allegation is 6.9 kg ganja recovered from the petitioner and on foreign ground. You can see the FIR is page 13.
Page 13.
Page 13.
In this case, we have a communication matter because one of the accusers approached the session judge matter. So CD was sent back.
And we already on released on.
So so CD is lying there, madam. So
CD is lying there only?
Yes, ma'am. So one time will be required.
So your petition is in custody since when?
30 March. 29 March. 2 days, 48 days.
29th
The
of March. The
release-
commercial quantity case?
No, sir.
Commercial
In between.
quantity. In
In
between.
In between, madam.
In between.
Not.
So 14th of March, what are you saying? 14th.
Today is 48 days, madam.
Today is 48 days.
From office to madam, lordship may kindly.
It was always been released by the land sessions of it.
No, we are not on that. The question is that we are calling for the case diary, CD not received.
Sorry.
As it was lying before the session judge, special judge whom?
Kamrup
Kamrup.
Metro, madam. And
Lordship, today is 48 days, lordship, kindly considering that.
Yes, Goswami, he is on length of detention.
since it's a NDPS case, madam, we cannot consider it, madam.
Honestly, something looking that.
Then do one thing, we will, till Monday, how many days will be there? Monday will be, Tuesday will be, Tuesday will be 53 days. So you take instructions regarding this punishing of the, if charge sheet is already there or charge sheet is not yet submitted, that intimation you can obtain. On Tuesday, we are fixing it. And by that time, we are also issuing reminder. And 50 Tuesday, we are fixing, he will take instruction regarding this punishing of the case charge sheet. If it is not yet charge sheeted, then definitely it will be a case for bail. I'm just asking because it's a
20.
2020. List on 20, issue reminder. And the learned additional PPs hereby also hereby directed to take instructions from the investigating authority as to whether the case has already been charge sheeted or not. On that day, it will be your 52 or 53 days, we'll consider it.
23.
Give it to the decision. I'll go. Give her.
Affidavit, I mean, action needed.
May please, your lordship.
Or you have not received the affidavit till now.
Let it be at 2, lordship.
At-
Or as per the convenience of the school.
At 2, I
Or
don't
as the
know.
last item.
No, we have obviously another hearing matters are also there. You have already filed, lah?
Yes,
We have already actually called for it. It's not today only filed, lah. They are doing some, the formal works, I think.
My lord's convenient.
Tuesday, one,
As a last item.
20. Last item I cannot say at this stage. Let us be in.
Let's try, lordship.
2. Acha, okay, then we are timing for it is dating.
Yes,
If it reaches, then we'll.
yes,
take
yes,
it.
yes. Lordship. High level.
24.
Wait, please, your lordship. This is an application under 483 BNs. This is an NCB matter, your lordship. Here, your lordship, in this case, the petitioner was arrested on 19/12/2022. Your lordship, I'll just take your lordship to the page 13.
1-3.
1-3, your lordship. Initially, I'll take your lordship to the page 10. Kindly take your lordship page 10. What was the basis of the arrest, your lordship? Information, your lordship, the basis, is 10.
Hmm.
Not the information recorded. This is the petitioner herein is your lordship Monirul Islam, that's right. On dated so and so at about, I received an information from reliable sources, there is a house at the address so and so, colony, Amingaon, and Jitul Ali is the owner of the house and he stored a huge quantity of so and so, so and so, so and so. He also carries gun. Jitul Ali used Monirul Islam at the same house as caretaker, and Monirul Islam also worked as a driver of Jitul Ali. So in fact, in this case, Monirul Islam has come, is the driver and the caretaker of Jitul Ali. Now your lordship will kindly take page 11, your lordship. I will not read this. Page 11, your lordship, basically this the prayer for custody was there. Prayer for custody, they already only asked for Jitul Ali, not for the petitioner Monirul, your lordship, in this. So Monirul was, and another accused, Atikur Rahman, was sent to judicial custody, and the Jitul Ali was sent for, was kept, given your lordship, I think, further custody. And then your lordship, the NCB submitted at page 13, your lordship. Page 13. I'll read two paragraphs. Page 17, para 8. What is the role actually? That is what I'm trying to point out first. Page 17. Para 8. That your lordship has got. Yeah. That in the meantime, two persons arrived at house number so and so, railway colony, where the above search and seizure was going on. On asking, they told their name is Jitul Ali and Atikur Rahman so and so. Monirul Islam told that the said house where search and seizure was taking place belongs to Jitul Ali and he works as driver of Jitul Ali. Monirul Islam also told that Atikur Rahman is also driver of Jitul Ali. Monirul Islam further told that Jitul Ali and Atikur Rahman come to the house every day. So and so I also showed his identity card to Jitul and Atikur Rahman and introduced with his team member and public witnesses so and so. So and so. Then your lordship, para 9. That on asking Jitul Ali, told that he has come to meet Monirul with his driver Atikur Rahman in Innova Krista car. This is parked outside the house. During search of Innova Krista car, so and so, a pistol with mark so and so with empty magazine was recovered from the dashboard of the glove box of the Innova Krista car, from which Jitul Ali and Atikur Rahman came to see Monirul Islam at the Railway East College. Now, your lordship, there is no specific allegation with regard to Monirul Islam, but only thing is that he is the driver of Jitul Ali, and since Jitul Ali is already, your lordship, is the main culprit or the main person in dealing with these seized drugs, therefore the conscious possession is shown because he is staying in that particular house and driver of Jitul Ali. That's basically the allegation against the present petition. Now, your lordship will kindly, in this case, your lordship, there are 13 listed witnesses here. 13 listed witnesses. Out of the 13 listed witnesses, three witnesses examination has been completed. Fourth was SIF only has been examined till date. Not beyond the SIF has been examined. Only the SIF has been examined with regard to the fourth witness. So only 3 has been completed. The fourth only SIF has been completed. So my first prayer is that there is already a delay. Now it's about, today it is about 2 years, 6 months in custody, your lordship. 2 years, 6 months in custody. And this delay, lordship, I'll just pray one ground will be long incarceration in this case, being your lordship. And second point is that since only 3 and the fourth is not yet completed, your lordship, it will take a long time, further a long time for completion of the trial. So therefore, there is this question of long incarceration is there, which is violative of Article 21 of the Constitution. Then, your lordship, the second point which was raised in this case is with regard to section 50 or 47 BNSS. Section 50 here, your lordship, as per the instructions, though I did not annex the annex one. It is there in the scan copy, but it could not be annexed here. I
have a flag mark here.
Flag mark for us.
Flag mark for us.
No.
Flag mark for you.
It is no. 50 or 47.
Flag mark lordship. I have flag mark.
Now you are appealing for
Monirul is.
Monirul.
Monirul.
So you have flag mark 1 4. This
No.
is for
Actually, see flag
Atikul.
mark 44 কইলাম Monirul of
Atikul হে কৰিলে আৰু কাম ক'ত আছে? দেখাই দিয়ক।
So see flag mark.
Probably it will be there. It is for Atikul Hissi flag mark.
And also one thing, your lordship, they have also filed their objection in this matter here. They have filed the objection here, your lordship. Basically, the objection is with regard to the factual and the metrics of the matter, your lordship, on merit here. So basically, it is on merit, and they have indicated the petitioner also, because on the fact of the case that they say that it is recovered from the conscious possession of Monirul Islam. That they have stated in their paragraph 13 of their this objection. That is 55 page. Because he is the driver of the Jitul Ali, and therefore he has conscious possession. That is basically overall, that is the version that they have stated in their and they have not
No,
stated
actually they have also took the ground of memorandum of arrest.
that part they have not stated, your lordship, in the because that is admittedly it is not there, so they have not stated. And your lordship, basically on the merits of the case and the facts of the case, they have stated and said that there is a conscious possession because he is the driver and he used to drive around Jitul Ali and he is there at that house, therefore he is a conscious possession. This is basically their objection, your lordship. And with regard to the DPS matter, your lordship, voluminous documents are there.
Anyway, we'll search
This
for
is
it by the
money,
way.
this is money.
Okay.
Yes, really.
Okay, by the time you can make your submission.
He denied that control and his involvement is not there. Lordship, his involvement is there, Lordship, because he was caught red-handed, and Lordship may note this, Lordship. He is involved in trafficking various drug contrabands, Lordship. Lordship, contraband 153.2 kgs of ganja, 179 grams of methamphetamine tablet, and 1.20 kgs of heroin, and 16 bottles of codeine-based cough syrup were recovered from him. He was caught red-handed. So, Lordship, it cannot be denied that involvement is not there. Involvement is there, Lordship. And regarding Lordship status of the trial, yes, 4 witnesses have been examined out of 12, Lordship, not 13, it is 12. 12, Lordship. And how, Lordship, status of this trial is there in our objection, Lordship. It is mentioned, Lordship. We have filed our objection, everything is there. how contraband was recovered from him, and the complete status is their lordship. And their lordship regarding section 50, your lordship record is their lordship. So, if you have any other witnesses.
Sorry, it is 12 witnesses, not 13. The 13, actually, they have given the number 13, but it is not a witness.
Your objection is here in this.
Record and lordship may note this charges frame on 6/11/23. 6/11/23, lordship.
Six.
So lordship, this is my humble submission, lordship.
I have marked that.
Yes.
15.
Just to লিখে রাখো, arrested on 19/12/2022. He was merely a driver and caretaker of one of the co-accused, Jitul Ali. He is no way connected in the LS offense. Only Jitul, I also prayed for police remand for only for Jitul Ali. From final report also, it is seen that there is no specific mention about, there is no specific allegation brought against the present petitioner. He is in custody for last 2 years, 6 months. But till that, prosecution could examine only 3 witnesses, and the witness number 4 is partly examined out of 12 numbers of listed witnesses. It will take considerable period. 50 CRPC, no compliance. State order cable, he was caught red-handed, and he was and the different type of contraband were recovered from the possession of the present accused petitioner, and thus it cannot be said that he is not involved in the LS offense. Rather, their recovery was from the conscious possession of the present petitioner. Charge was framed in this case only on 6/11/2023, and till date 3 witnesses have already been examined by the prosecution, where they have implicated the present petitioner. Bakikhini rest these are the gist, and Baki you can submit on 50 CRPC plea of 50 CRPC, non-compliance of 50 CRPC. Okay, then we'll pass you.
I have also charged with long incarceration.
Yes, long incarceration. 2 grounds, 1 long incarceration, other one is.
Much obliged.
Kita lomba goal. Lomba kita goal. Dangor kiri kita. Lomba
May it please, sir.
Yes.
Regular bail application manner, intermediate quantity. 53 days behind bars, madam.
Somehow you are on intermediate quantity.
Yes.
Otherwise, commercial is.
Yes.
Anyway, you are on 53 days
53
custody.
days.
Yes, what about the
My
case
CD is
progress?
there, madam. The CD is there, as I said, noted, it is 5.63 grams conscious possession.
FSL is already obtained.
FSL, my lord, is
Apart from 53, is there any ground?
Then 48 notice, madam, that those grounds are there, madam.
But otherwise 53 days.
Otherwise, length of detention, madam. The last page, my lord, page number 22. 22, that is the 48 notice.
This is 48.
48.
And 47, there are
40
some grounds.
47 notice, yes. They have simply pasted the results from the forwarding report. That's why I'm not on that matter. I'm on length of detention matter, 53 days.
Yes, FSL report is not yet collected.
Not clear, my lord, whether received or not.
Heard Mr. Esdal, the learned counsel for the petitioner. And also heard Mr. MP Goswami, the learned additional VP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. CD receipt, payment receipt. It is submitted by Mr. Das, the learned counsel for the petitioner, that he is innocent and no way connected in the alleged offense. However, he is in custody since last 53 days, and thus the IO got sufficient time for his custodial interrogation. And hence, considering his length of detention, he may be released on bail. Being the permanent resident of his address locality, he will appear and cooperate in the investigation of this case as and when his cooperation will be needed. Next para, Mr. Goswami, the learned additional PP, submitted in this regard that there are sufficient incriminating materials against present accused petitioner. However, the IO could not collect the FSL report till date, and case is not yet charged.
Yes, that may not be accorded regarding FSL matter.
FSL not yet collected, na?
As per the CD, it is.
It is collected as per the CD.
No, my lord, nothing is there.
That's what I'm saying,
Yes,
not
yes,
yet collected only, not yet collected. Next part, considering this so and so, only merit of the case query. This is from where?
Baksa, my lord.
Baksa.
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 Special just Baksa.
Special just Baksa.
Special just Baksa. Okay, that's.
Right. Highly obliged.
42 of the supplementary list.
So can it be after sometimes, my senior selection code number 3.
42.
After some, he will be coming.
Otherwise, you are appearing for the respond number 2.
He'll be coming only, ma'am.
Okay, okay.
Obliged, ma'am.
43.
May I please?
It is.
CD received, huh? It was fixed yesterday only?
On 13th, Lord.
Oh, 13th. Acha, acha.
It was listed on 13th and today was fixed.
Okay.
The informant has appeared.
Yes, he has already appeared. Earlier, we have engaged actually Mr. D. Gogoi, but subsequently Mr.
Lordship.
Kalida had appeared. Okay.
This matter, Mr. I Fukon, he was appearing, but due to some emergency, he has to leave.
So now you are appearing on behalf of him?
Lordship.
Okay.
Otherwise, Lordship, 52 days in custody, section 10.
Section 10 POXO,
Section 10 POXO,
52 days.
52 days. My prayer, Lordship, at this stage, even police has never sought for a single day custody. At 52 days, he is in jail till date. My prayer is, Lordship, he may be allowed to go on bail on any condition, right?
Yes, does.
So should implicated in 183 instead.
183.
Yes,
The girl implicated.
yes.
Yes. Yes. Hold it.
There is serious allegation, my lord, against the accused.
Need to
And
skip
one
to the
is also
183.
implicated, my lord.
Pardon?
Yes, my lord.
Yes.
That is, my lord, as far as there is serious allegation against the accused, my lord. And my lord, he has implicated also, my lord, in 183. That is my submission.
But if your lordship comes to my petition, my lord. In paragraph 10, 9, 10 and 11. Oh, stated our defense. That is the actual issue. In paragraph 9,
10.
Lordship. Even my daughter, she also visits the school in the same school van, driven by her father, along with the victim.
No, your daughter?
She is studying in class 9 and used to go in the same school van.
School van.
Along with the victim. The accused, he is the driver of the school van wherein the victim used to go to school. And daughter is also used to go to school in the same school van. If lordship comes to paragraphs 9, 10, and 11, page 8, basically that is our defense. And even on the previous day of filing of the FIR, the grandparents, along with payee of that victim, they threatened me. I have stated in my paper.
Why? What is the reason?
On the previous day of the filing of the FIR, my lord, the grandparents of the victim, along with her aunt, they visited my house and threatened me.
No, why? Why you have treated?
Lordship, if lordship comes to paragraph 9, my lord, they suspect that I am having some relationship with the mother of the victim.
Achha.
Otherwise, my lord.
And FIR was lost by whom? Father.
Father. I have annexed the iCard of the daughter of the accused.
Allegation is very thing, na? 183 statement is very, it cannot be considered in.
Considering the detention.
No, the statement is very bad.
Then my lord may.
Very bad statement.
Look,
I
I
must say,
understand.
though it is a case of 10 FOXO, that's
Look.
very bad statement.
Then my
Very
lord may fix
vulgar
it on
things that have come.
Monday. Mr. Fukon will be available.
But Mr. You are Mr.
P. Chaudhary.
P. Chaudhary, appearing on behalf of Mr. R.B.
R.B.
Fukan, R.B. Fukan, the counsel for the petition. And also heard Mr. MS Andas, the learned additional PP, appearing on behalf of state respondent, and Mr. M. Kalitan, appearing on behalf of the respondent oblique informant. His diary has already been received. Perus the same. It is submitted by Mr. Chaudhary that the present accused petitioner is innocent and he has not committed any such offense as alleged in the FIR, but only due to or only for some grudge on him, as he was suspected to have a relationship with the mother of the victim, the present FIR has been lodged against him with some false and concocted allegations. However, he is in custody since last 52 days, and hence, considering his period of detention, he may be released on bail. Post of being a local resident of his address locality, he will extend his cooperation in the further investigation of this case if it is needed. Next para. MS does the learned additional PP submitted in this regard that there are sufficient inflammatory materials against the present accused petitioner in the case diary. More so, the victim had incriminated the present petitioner while recording her statement under section 183 BNSS. Admittedly, the victim was a minor at the relevant time of incident, and considering these aspects of the case, his petition may not be considered at this stage. Next para, Mr. Kalita, the learned counsel appearing for the respondent number 2, submitted in this regard that this is a very serious allegations brought against the present petitioner by a minor girl of the minor victim, and hence considering considering the materials in the case record as well as the statement made by her the petition may not be considered at this stage. And accordingly, he raised objection in granting bail to the present petition. Next, considering the submission of made by learned counsel for both sides, I have also perused the case record and the case diary, especially the statement of the minor victim recorded under section 183 BNSS. Considering her statement and other materials in the case record diary, I do not find it a fit case to allow the accused person to go on bail at this stage, only considering the length of detention. Accordingly, the same stand dismissed. Your petition stand dismissed.
Deeply.
বাচ্চা ছোৱালীটা ইমান বেয়া সৰু বাচ্চা ছোৱালী ইমান বেয়া কৰিছে
28.
They did not receive lordship.
May I plead your lordship? Petitioner, both the petitioner arrested on 5/5/2005. I want to withdraw this petition.
They are already arrested.
Yes, my lord.
Both the petitioner.
Both the.
You are MS
So,
R. Begum. Hard MS R. Begum. You are appearing on behalf of Mr. H. Anjaman, appearing on behalf of Mr. Anjaman. And also heard MS Endas. So and so it is submitted by Endas that she did not receive. However, MS Begum submitted that both the petitioners are already arrested in connection with this case, and hence she wants to withdraw the same, as the petition has already become infructuous. Bear a lot. Okay, your petition is disposed of on infructuous.
31.
Your lordship, order my lord, last in time order is page 24, order dated 25/4/25.
Yes.
This is the Gaubuga my lord, earlier your lordship rejected his petition, my earlier. Second time I came and since he is a Gaubuga, he was entrusted in the election duty, my lord. On that ground, your lordship was pleased to grant bail on 25/4/25. You will kindly see your lordship order, my lord.
Yes, yes.
So now he appeared, my lord, and I think, my lord, because he is all the persons, my lord. Your lord, kindly see the FIR. Just have a look at FIR, my lord.
FIR that page?
Yes. Page 71/7.
Page 17.
1/7.
1/7.
1/7. Occurrence took place in front of his house, my lord. And your lordship kindly see 11 persons named in the FIR. Out of 11, present petitioner is number 1. And all them are my lord, his sons, nephews. Only all of them got interim bail. AB, subsequently it was made absolute, my lord. Only one person was arrested, that is one Abdul Jabir, accused number 7. So he was already also granted bail, my lord. He was arrested, Abdul Jabir, accused number 7. Arrest already, all of them get bail, my lord. So my prayer is, my lord, he is this old person or a government public servant, my lord. He already appears, states also recorded, my lord. Your lordship may make absolutely subject to what your lordship and my learned friend say, my lord. Only, my lord, his allegation in front of my lord, page 17, middle portion, your lordship will find that in front of the house, my lord. Accordingly, your lordship will find second paragraph, page 17, 4-5 line, my lord, your lord. It was possible, 2 accused persons were, my lord, they were looking by the police, my lord. And they were the wrong person, so they have arrested them, my lord, taken to custody, and the people came to the gathering, about 2,000 to 3,000 people, and they have taken away him. This is the case, my lord. And that occurrence took place in front of the house of Majorali, your lordship, the 5th line, my lord. Forcefully stopped and vandalized by the below noted persons at Mandia area over mode in front of the house of 5th line, my lord. In front house of Majorali, Gaubuga. The FIR named person assaulted the police personnel boarded in the said vehicle and in the said incident. One police person, namely so and so, sustained grievous injuries. So about 3,000 or 2,000 people gathered there. Your lordship also observed the idea that's order, my lord. So in that way, my lord, and he came out, it is true, my lord. He helped the government, my lord. He informed the OCF that the police. Now all the members of family have been, my lord, implicated. All his sons, nephews, all family members, my lord. Because he is a Gaubuga, my lord, political Gaubuga is there, my lord. So this is the case, my lord. So my case is, my lord, in the light of that, my lord, shuffling up a case, my lord, your worship. So he joined, my lord, he is cooperating. If there is anything, my lord, your worship may give them liberty to cancel the bill, my lord. My only prayer, my lord, 61 years old man, my lord. And all other persons got bail, my lord.
Yes, what?
Earlier rejected by.
Earlier it was-
Yes, sir.
Finding sufficient materials
That
against
is-
the accused person.
That I am not disputing.
He is the governor of the village, police personnel, I'm sure also in uniform, Otherwise, his duty is to prevent,
That's true.
help those police
Yes,
persons, my lord. However, my lord, those accused person, the present accused person appeared before a statement recorded regarding one note of the just point out, my lord.
Yes, so
This is only as per their statement, madam. Otherwise, other accused person stated that they are. Because initially, my lord, interim bail was granted to the petitioners.
yes.
Oh, at that point of time, bail was granted because petitioner was interim was there, my lord, and thereafter his statement recorded. Otherwise, my lord, being a Gaubra, he could have prevented, my lord. He could
That's
have
true, madam. I'm
at
not
least
denying
helped
that.
the police personnel, but
We should have my lord.
otherwise,
Now it-
otherwise, my lord, the accused persons also, my lord, stated the name of the
Gambra.
Gaubra. Initially, my lord, interim granted.
61 years age, my lord. Only just. And if you lost one, I am not sure I'm disputing that my learned friend has my lord. Only because since he joined my lord, that it will facilitate the RD disposal of the case.
There were some statements made by some of the witnesses or the co-accused person that he is the, actually, though he was a Gambra, he took the part in this. So on that basis, actually, it was rejected.
And on-
We can consider, but I will note now
That is,
at
that
this.
is only on the basis of the statement, while the interim, but otherwise, my lord, this type of offences, my lord, gathering of, my lord, mob, thereafter attacking police personnel, my lord, this type of incidents.
Come on
are
now.
Yes,
continuously
nowadays it's
going
common.
on. And suppose on that day, 2,000, 3,000 people, if some, my lord, police personnel on, in that, my lord, on that day, my lord, something, my lord, do not happen, my lord. If somebody, some of the police personnel, any major injury, if someone killed, then what will happen? My lord? These are the questions, my lord.
Nowadays, even my lord, people when they gather, my lord, even though they do not listen to the what elderly people say, my lord, they take on their own, my lord. This is how it is happening nowadays. Every day we find, my lord, newspaper is coming one. Sometimes they become out of control, my lord. Though they also cannot do, my lord. The senior persons, my lord. Mob, my lord, they become prevalent over the other persons, my lord. Anyway, my lord, 61 years, I think your worship, my lord, your worship, and this, whatever conditions, my lord, otherwise service also will go, my lord.
Part Mr. H.R. Chaudhary, the learned senior advocate, assisted by Mr. S.S. Ahmed, the counsel for the petitions, and also heard Mr. P. Botaku, the learned additional VP, appearing on behalf of state respondent. This is an application under section so and so in connection to so and so. CD receipt, benefit sale. It is submitted by Mr. Chaudhary. That present accused petitioner is a Gambura and a public servant. And on the day of incident also, he was trying to pacify the persons gathered there in front of his house. However, after getting the order of interim pre-arrest bail, he appeared before the IO, cooperated in investigation, and his statement is also recorded under section 183 BNSS. He further submitted that he is still ready and willing to cooperate DIO in further investigation of this case if he is granted with the privilege of re-arrest bail. Next, Mr. Botapur submitted the learned Edison PP submitted in this regard that his earlier bail application was rejected by this court, considering the statement of some witnesses as well as co-accused persons. But it is a fact that after obtaining the order of interim pre-arrest bail, the statement of the present petitioner was recorded, and the I also gave a note into that regard. He further submitted he is now
That-
cooperating. Pardon?
That note was only because at that point of time petitioner was in interim. But that is only the record of the statement of the accused.
Yes.
But from the other materials, that
Materials,
petitioner is involved, that is, my lord, materials is there.
He didn't ask for note to kid. Note, have to give a note after recording the statement of the present petitioner. First, however, Mr. Botapur submitted that there are materials against the present petitioner showing his involvement in the arrest offense. Next, considering the submission made by learned counsel for both sides, present conduct of the present petitioner at this stage, and other aspects of the case, I find that custodial interrogation of the present petitioner may not be required for the interest of the investigation. Absolute voidable.
25/4/25 interim order.
25/4/2025 is hereby made absolute with the same terms. and
Obliged.
conditions.
May I please
Yes.
your lordship?
Yes.
Well, here
Here we have received the case diary.
on SI of police lost the affair before the Golfara police station. FIR is split 13 miles. In his FIR, Madam, it stated that informant got the information from reliable source that some place of that area, but IPL betting online through mobile phone and Malot gambling is going on. Accordingly, a police team searched the one particular place, that is the shop of the present petitioner. And the employee of the present petitioner, 2 numbers and along with other person, 3 person found police there and caught them and attended staying there and forwarded. And subsequently, the police team searched the house of the present petitioner. And in the FIR says that 9,57,000 was found in the house of the present petitioner. Now, my lord, the humble submission as per my instruction, my lord, 3 person was arrested. Out of these 3, 2 person on Shahidur Rahman and Hare Krishna Das. They were the employee of the present petitioner. My lord, shop run by the employee. He only particular sometime come and look after. And that time what happened, he is not aware, my lord. And my lord, in regard of the present petitioner, very unfortunate, my lord, that only the money was recovered from the house. One house is distance from the shop, my lord, other place. And police suspect. And my lord, he is a businessman, my lord. And the money kept at home, my lord, for the purpose of purchasing, my lord, battle nut and other grocery shop, my lord. So my humble submission, the present petitioner is no way connected with that gambling, because the bank statement, it will be clear. If anybody will not play IPL, it must be transaction through bank, my lord. So whether,
Must be. Why?
my lord, suppose a person, my lord, gambling in IPL, my lord, then bank statement will say the money is credit, debiting, everything, because offline it is not the system, my lord. Sitting here, my lord, the another state or long distance, my lord, game is going on. So my humble submission, only on the basis of recovery money, the police suspect.
So you have also annexed the bank statement here? No.
No, my lord, I have not any because I had present, my lord, police is running behind me. it is the duty of the investigating agency, my lord. Whether any transaction is going on from the account, my lord, and it is crediting, that another thing. Otherwise, only cash money is recovered from my house. Police cannot suspect because my employee may be involved. I do not know because whole the day they stay in the shop from 8 to 10 p.m. my lord. And every day I don't visit my shop, my lord. So my humble submission, my lord, kindly examine in which way only on the basis of some cash recovery from my resident, police can say I am also involved in the IPL. Since my employee is involved, because employee and my status so many difference, man. And I am the businessman of the locality, reputed person, my lord. And they are the salary based, my lord. So kindly examine the case diary on the basis of verbal statement. Police cannot say that I'm gambling and I'm involved in IPL, because bank statement must be there. Otherwise, nobody can transact it.
Yes.
Whereas my lord, case diary received, my lord, on the basis of source information, police searched the place of the present petitioner. And thereafter, my lord, what read, handed my lord they are apprehended my lord, 3 accused persons, Sohidur Rahman, Hare Krishna Das and Vikas Das. And from Sohidur Rahman, 30,000 was recovered. And thereafter, from the residence of the present petitioner, my lord, 9,58,000, 57,000, along with iPhone and some tea tickets and others also are recovered from the other, my lord, from the place of the occurrence. And my lord, regarding the submission of the present petitioner, my lord, at that point of time, my lord, from the statement of the other accused person, it reflects that by using one online app, my lord, 666, they were, my lord, running all those, my lord, IPL bettings and my lord, selling of tea tickets. And regarding, my lord, here only allegation is not IPL betting, selling of tea tickets is also there. So, my lord, how those, my lord, and regarding his, my lord, submission that only through online, my lord, how he is getting all those money on by selling tea tickets only through online, my lord. My lord, now he will have to, while he is submitting that, police will have to, my lord, check his bank online transaction, everything. First, he will have to annex those, my lord, bank transaction, my lord, in his bail petition, my lord.
No, that is the duty of the investigation.
Yes, that is the duty
because
of the
every
investigation.
person,
It is right.
on what basis? What is the basis? And police search my house. I am a businessman, reputed businessman. My lord, transaction is going on every day with different customer in cash also. If my lord, money is found, then the IT department can issue the notice. I will reply there. What is the money? How the money has come? Only on the basis of recovery cash money, since my employee is involved in other offense, my lord, cannot doubt, my lord. Very unfortunate case, my lord. I will appear before the police officer.
No, but
and I will
apart
cooperate the
from
investigation. ma'am.
the recovery of money from one Sohi to the arrested person, what other information is there?
Selling of tea tickets, my lord. These are the two, my lord. Tea ticket.
My house, my lord, nothing, my lord, except money.
From your house, 95,000.
Yes, no, money, I may admit. It is not the IPL money.
These are the, my lord, Caesar list, my lord. I will point out.
Tea tickets were also recovered from his house?
Not from his
No,
house, my lord.
Not from my house.
Because, my lord, search was made in the shop of the present petitioner, my lord.
Because already I have mentioned, and police also found they are the employee, my lord.
These are the
They are
Caesar
the
list.
employee of my shop. I am not running the shop. My employee running the shop.
Which Caesar list, man?
All the Caesar list from my lord, my employee.
And my lord, in his shop, his employees is
And
what they are
my lord,
doing, my lord, selling tea
It
tickets
is
and
not, my lord, the forcefully police details. Because I am confident my employee never can say my involvement. Because they did not disclose any day if they are doing another thing in the shop. Because every day I strictly look after, and they said that we are running and we are busy with business.
CCTV.
In my
footage is
absence,
also
my
there.
lord, they may do something. That is another thing. But being a master, my lord, and the employer, my lord, I am not responsible, my lord. That is the independent offense. So money recovery from my house, my lord, I will give the reply, my lord, another way. When regarding keeping the cash money at home, if charged, my lord, then I will reply there, my lord, but not connecting this TIR and IPL, my lord.
So from her, his house also, one iPhone, and apart from some T tickets and IPL cricket, there are also some tickets were also seized as per witnesses.
Well,
And
these are-
CCTV footage was also
He is
there.
directly involved, my lord.
No.
From his shop, my lord, this type of, my lord, transaction is going on, my lord, game is going on, selling of tickets, my lord, online, my lord, betting, my lord. He is not at all aware how that can be, my lord.
Some business rival, my lord, and by conspiracy, my lord, forcefully, my lord. It was forced my employee to tell about me, and the visited in the, my lord, jail also, my lord, they said that it was a force. My lord, indirectly, my lord, the petitioner is, they are trying to harass, my lord. But main fact is some businessman and some business rival is doing this story, my lord. He is very reputed person, my lord. In his life, my lord, never a single, my lord, offense can say, my lord, in the locality, my lord. So, my lord, I will appear, my lord, I will cooperate the investigating agency, my lord. And since the offense, my lord, is 3 years punishment offense, my lord. So it is not so very serious offense, my lord. So I am praying, my lord, at least the honorable court allow me to go on bail. Anyway, my lord, I will cooperate the investigating agency. If found finally investigation complete, my lord, I will face the trial, my lord. But I have the confidence, my lord. And if I released on bail, everything I will disclose before the policeman. Who is behind this
So you know
story, my lord?
everything.
My lord, who is behind this story, my lord? Because some
Right.
business rivalry, my lord.
On
is,
one hand, you are saying you are not at all
Yes.
involved, you don't know anything.
Other
On
way-
the
No, my lord.
other hand, you are saying that you will be
No,
disclosing.
my
all
lord,
things.
I am saying this way. Who is person behind me, my lord,
Acha.
the
to
name-
harass me, my lord? I am saying on that point, my lord.
He
Yes,
made a
what
lot of arguments regarding bank transaction. He know the name of the person.
No,
He knows everything, my lord.
no, I
but
know the
not
person,
named
my lord,
anyone in-
who is person is, my lord, trying to harass me, my lord. They are not the person of IPL related. Another person, personal grudge with me and business rivalry. And my lord, if bank transaction found, my lord, then can say yes. Because it is online system, my lord. Only cash money.
No, tier tickets.
The TIR also, my lord.
Tier also online?
Yes, TIR also online, my lord.
I was not aware.
Yeah, TIR also online, my lord.
Then
Without
why he has
on,
not
because
annexed his, my lord, bank transaction, my lord, in his bail petition, my lord.
No,
no,
it's not annexed.
And not annexed.
I have not annexed because, my lord, it is the duty of the investigating agency.
Yes.
Cash, they have
Oh,
found the
agency is
cash from
doing
me
now.
on suspect, my lord. So kindly may consider, my lord, it is not serious offense, my lord. 3 years punishment, my lord, here.
One hand he is admitting.
So, my lord,
everything.
not
This guy-
10 years, No, my lord, I am saying that another way, in different way, I am submitting, my lord. The honorable court may consider any ground of my submission, my lord. I reputed person, my lord,
Heard
very-
Mr. Anutin, the learned counsel for the petitioner. And also heard Mr. P. Waterford, the learned additional PP appearing on behalf of state respondent. This is an application and section so and so in connection with so and so. City receipt bears the same. It is submitted by Mr. Uddin, the counsel, learned counsel for the petitioner. That present petitioner, that he is innocent and no way connected in the alleged offense. It is a fact that his three employees were arrested in connection with this case. With the allegation that they were playing tier and also the IPL online betting. But the petitioner was not aware about anything what was doing by his employees in his shop. Further, he submitted that an amount of rupees 9,50,000 was recovered from his house, but that is from his other business transaction, as he is a businessman and he is no way connected in the alleged offense. He further submitted due to some business liability, his name has been mentioned and showing his involvement in the alleged offense. However, he is ready and willing to cooperate the IO in the investigation of this case if he is granted with the privilege of pre-arrest bail. Next paragraph, Mr. Botaku, the learned additional PP submitted in this regard that 3 of the employees of the present petitioner were arrested in connection with this case, and from the available materials on record case diary, it is seen that the one of the accused, namely one Shahidul, rupees 30,000 in cash was also seized, apart from some tier tickets and mobile handset, wherein they used to play the online gaming and betting for IPL with an app, online app full stop. Mr. Botaku further submitted that from the materials in the case record, it is also seen that the present petitioner is also involved in the alleged offense. And from the CCTV footage also, the police had recovered. The IO got the information about his involvement in the alleged offense. Mr. Botaku submitted that.
Otherwise, his submission that those apprehended accused persons are the employees of the present petitioner. There is no such.
Out of
There is no.
It is not in the record. There is nowhere it is reflected that the present apprehended accused persons are the employees of the present petitioner. That is only his submission. That
In the FIR categorically saying, it is a fact. Because you see that is my shop.
Your shop, but
Yeah.
those accused persons who were arrested,
Shop
that
there.
is your
My
submission.
shop running by the employee. madam. I have a clear the statement.
But whether those apprehended accused persons are the employees
why-
of the
why they
present
will come in
petitioner
my
or
shop?
not, my lord?
No, my lord. They are a employee of my shop.
In the FIR itself, it is stated, I think, you see. They are the employee, I think.
The only, my lord, shop run by Gautam Das in presence of 2 independent witnesses.
I have no-
During search at the place of occurrence, below mentioned 3 persons were caught red-handed while they were selling tickets and betting IPL game by online through an app named Stylus.
My submission recorded there. I have on oath given the statement. They are the employee.
Further, Mr. Botaku submitted that there is no evidence there is no statement made by the witnesses or in the FIR that the 3 arrested accused persons were the employee of the present petitioner. Accordingly, Mr. Botaku raised objection and
That
submitted.
may not be recorded, my lord. If otherwise they are employee while he has already submitted it.
Okay, accordingly, Mr. Botaku raised objection and submitted that it is not at all a fit case to grant the privilege of pre-arrest bail to the present petitioner. Next paragraph, considering this submission made by learned counsel for both sides, materials in the case record, case diary. And other aspects of the case, I find that the present petitioner may be given one chance to appear before the IO and to record his statement accordingly. In view of this, interim matter DD. Okay, you will be under interim, cooperate with the investigation, appear before the IO, and your statement will be recorded accordingly. What is saying, Mr. Botaput, is that this case I have seen, though there is some statement that money is recovered from him and there is CCTV footage. What was CCTV footage shows or what is this? Nothing, in fact.
Yes.
They have, so far the investigation is concerned,
Yes,
till
sir.
now. There may be some, but
Somewhere there
investigation is still going on.
Somewhere there is mention about CCTV footage,
CCTV, yeah.
but there is nothing, my lord, in the there is what actually reveals that footage.
CCTV footage,
There is-
because CCTV footage will be there,
But
there may
the-
be
yet,
employee,
my lord, probably
as they are
investigation
employed,
is
they
going
may come to the house of the accused
Yes, yes,
petitioner
yes,
also.
yes.
But how he is involved or what has been shown in the CCTV, that is not there, in fact. I have seen, in fact. So
Probably
let him
will-
appear once,
during
cooperate, we'll
yes,
see
yes.
if it is there in MAC or not. Okay. Interim to DD, huh? Okay, I will be under entry. Take CD. Yeah. Date, yes, what happened, date can be
June, my lord, 5th of June, my lord.
5th of September.
44. 44 of the supply list.
Yes, 44. MM on 44. Standing Council NF Railway is not here. Standing Council NF Railway is not here. Who is appearing in fact? Standing Council NF Railway?
Earlier this case was allotted to me, probably.
Was allotted to you.
But later on, I handed over the matter to A. Kayan. So I will.
A. Kayan was appearing.
Last one.
But now the M.A. Mondal is also not present here. None appears on call for the petitioner. List the scanned copy of the case record has already been received. List the matter accordingly after 2 weeks. After 1 week. Okay. Yes.
Standing 2 and 10.
Your Lordship, I have also gone through the case record, Your Lordship. Your submission of the charge sheet, the Honorable Trial Court, the frame charge on by the order dated 3/9/2024 on the record. And out of the 10 witnesses, evidences of
3/9/2024, he was arrested. No, what
no,
you
no,
say?
no, 3/9/2024, the charge has been framed.
In item number 2.
Item number 2 and 10,
10.
same thing, Your Lordship. And out of the 4 accused, 2 has already been granted bail. One by the
No,
Lord
no,
Court
you
below.
can just tell us, charge was framed on?
By
Charge framed
order
on
dated 3/9/2024.
3/9/24, charge framed.
Charge framed.
And your petitioner is in custody since?
Since 22/6/2022.
22/6/2022.
That is more than 2 years, 10 months, Your Lordship. And out of 10 witnesses, 2 have been examined. It is in the record. And Your Lordship, I have also seen that out of the 4 accused, 2 have already been enlarged on bail, one by the court below and one by this Honorable Court, Your Lordship. And Your Lordship is very aware of the Supreme Court Judgment Ravi Prakash, Your Lordship. Already 2 years, 10 months, Your Lordship. This is the insertion of Article 21, Your Lordship. So Your Lordship order is also there. I have Ravi Kumar is also there. Many coordinated judgment I have already, which Your Lordship I can furnish if necessary, Your Lordship. So any condition, don't bail you.
So basically you took the ground of long incarceration.
More than 2 years, 10 months, Your Lordship.
And is there any other ground for non-furnishing?
Yes, even in the notice under section 25, there is no ground of arrest here. I have seen from the record. And two co-accused has already been granted. Here the accused is one is driver and another is co-driver.
Yes.
Final complaint is not there, Lordship. I have gone through the seizure memo, Lordship. Contraband record from the petitioner, both of them were inside the truck, Lordship. They were caught red-handed, Lordship. And yes, Lordship, final complaint filed on 16/12/22. And Lordship charges frame on 3/9/24. In between, Lordship, matter was fixed for copy, production.
Your charge sheet was submitted on? Final complaint was?
16/12/22. And charges frame on 3/9/24. In between, Lordship, matter was fixed for copy, production, and GMA report, Lordship. After that, Lordship, after framing of charges, Lordship, witnesses are coming. Lordship, I have flag mark, Lordship, and Lordship, till now, 2 witnesses have been examined. And Lordship, I am unaware how many witnesses are there because
It
the
is,
final
it
complaint
is
has
in the
not been
record, Your
annexed,
Lordship.
No, not there next. Have you seen there in your case record?
Yes,
In
it
You
is.
were asked time to, you were
Your
pre-
final complaint is not there in case record, Lordship.
case record also.
Yes, Lordship. That is
Huh?
why. Lordship,
But why it is not there?
there is record.
Page 10 of my petition, there are name of 10 witnesses. Apart from seizure witnesses, another 2 seizure.
From where you are saying 10 witnesses?
Page 10.
Page 10.
Page 10 of my bail petition in item number 2. Page 10. Your Lordship got.
Yes. Where the?
Serial number 5, Manjesh Kumar, and serial number 7, Janak Das Sipoy. Only these 2 witnesses have been examined. There are 10. Then there are apart, Your Lordship, there are another 2 seizure witnesses and page 18. Page 18. One para above the last para. After reading, so I approach the person who was present there and I introduce myself on asking, they conveyed their name, Pankaj Musari 1, and number 2 is Aditya Tenen. So 10 plus 2, 12. Only 2 have been examined till date, Your Lordship. And we are languishing since 22/6/2022, Your Lordship.
No, but you cannot exactly say whether 12 witnesses were there or not.
Because Lordship, list of.
No, it is also in the
List of
record.
witnesses.
I've gone through the record.
Record?
Yeah.
From where
Also
you are
to-
saying?
This page 10 and election is also in the record.
No, no, no. We are saying that complaint, final complaint is not there or the charge sheet is not here.
This is Lordship, office order, Lordship.
These are the office order. These were subsequently they were
But
made
they already
parties, they
reflect
were
their-
made witnesses or not. We cannot say at this stage.
Now I have gone through it. There already the final report has been submitted. 4 set of charge sheet have been submitted. It is recorded in 27/7/24. No? I have gone through the record.
Record.
Yeah.
Then why she is saying that complaint?
I have
complaint
gone
is
through
not-
the record myself. Awesome. Record.
Record today.
Charge sheet is not there, but submission of 4 set of offense report is the charge sheet. Offense report. In NDPS case, offense report is the charge sheet. Especially second part of it. Is reflected in the order.
In 10
Your
also,
Lord-
in 10 also, he was arrested on 22/6
Your Lord-
2022,
Para 14, para,
same day.
yes, same day. Para 14. Para 40. Reflect. Thereafter, the
No, no,
it came up-
obviously there has to be some final complaint or the offense report.
Obviously,
Without
your-
the final offense report, but I'm surprising why it is not there in the
Yes,
case
yes.
record. It's not here. This is
Obviously-
the order only. This is not.
Yes, yes. I have also concerned, I could not find the final charge sheet, your lordship. It is not.
This
there.
is
It
whose
there left on the
copy? This is whose copy? No, no, itu try niki part of. Acha.
Yes. So for the lapse of the, on the part of the person, the petitioner should not
But
be
in
suffer
Likilo,
your lordship.
arrested on 22/6/2022. Final charge sheet was on 16/12/2022. Charge frame on 3/9/2024. 2 years, 10 months. 10 witnesses, only 2 examined. But long incarceration, 8 April. Section 50 CRPC not ready. He is the driver, public co-driver of the vehicle, and they were not aware about the contraband. He can tell for submission, long incarceration, their submission will be there. And from the state of submission that the final complaint was filed on 16/12/2022. However, charge could be framed only on 3/9/2022, as there were some other formalities to be observed, which took a considerable time. But the case is at present at the stage of evidence, and 2 witnesses have already been examined by the prosecution. She further submitted that the contraband was recovered from the conscious possession of the present petitioner, and they were well aware about the contraband, well aware about the availability of the contraband in their vehicle. Pakihini, rest of the submission will be seen. So we have some yes, any other submission.
They have stated that 2 accused person got bail, lordship, but nothing was recovered from them. But here, lordship, contraband recovered from
their position.
Obviously, not from the truck. We are driver and co-driver.
I'm relying
Obviously,
on judgment,
I am not.
lordship. I have a bar, para 11, lordship.
Yes, it is a fact that is contraband has been recovered from the truck, and we happen to be the driver. It doesn't mean owner is there. Other person. Companion are there.
She further submitted that the submission made by the London Council for the petitioner that the 2 co-accused persons were already granted bail is not on the same footing of the present petitioner. As in the other 2 matters, there was no recovery of contraband. There was no recovery from the conscious possession of the petitioner, co-accused persons, but here in this case, the contraband was recovered from the conscious possession of the present petitioner. First off, in that regard, she also cited a decision of the Honorable Supreme Court. Itu lo reported tomorrow. Yeah, already soon. April 28 দিতে হবে, হ্যাঁ April নম্বরটা দিতে হবে, কারণ কোনটা সাইটেশন ধরবো প্যানেলে এটা দিলাম, এইটার মন মার্ক করে দিছো, প্যারা 11 you can search. Need to form from the petitioner, from the respondent side, huh? You'll have a mark with it. Yes, what is this?
Herein also they earlier relied on the same footings in another case that was not taken into
Coordinate bench?
by coordinate bench.
Okay. Okay, we'll pass the order.
Much.
Packet to load the order. দুটা 2 and 10 same order will be there. One driver, one is co-driver. What is the month of the- This one is the month. To the person. This is ambiguous. Mm. খালি মই বেলেগ একো লিখিব নালাগে, বেলেগ চেম থাকিব, এটা খালি যিটো ৰেচপন্সিবিলিটি ব্লু হেৰিৰে লিখি দিছো সেইটো খালি বাকী লিখাব খালি উলিয়াব। Oh. If you only BC, then it won't reach other one. What to be some of the only BC to it.
For orders, item 33, upgraded.
May I please?
So here, one VC request was also there.
Yes, Mr. Biswajit Dev, he from Kolkata Lordship. He is requested for BC Lordship. I am assisting him Lordship.
You
My
are-
lord,
Yes.
my lord, am I audible?
Yes, yes.
I'm, first of all, my apologies, my lord. I was supposed to appear physically, but due to my illness since the last 2-3 days, I am unable to come down to Guwahati and appear physically before your lordship, for which I apologize. And that is why I am appearing through VC, my lord. Now, my lord, this matter, I am appearing for the respondent state of West Bengal. Now, my lord will see that there is absolutely no
State of
cause
West
of action.
Bengal is respond number 2.
Yes, Lordship.
So you are supposed to file your written objection. Have you filed?
Yes, written objection is under process, my lord.
Is under process.
Yes, yes.
Under process.
It will be filed.
Yes.
It will be filed in the course of the day.
Also.
By today, it will be filed. My lord, so far as the cause of action, my lord will just bear with me for a minute. So far as the cause of action is concerned, my lord, there is absolutely no cause of action against the state of West Bengal. State of West Bengal has got nothing to do with this matter. It's a litigation between two private parties. It's a civil litigation. It's a claim for some business monetary issues between two rival parties. And state of West Bengal has got nothing to do and has been arrayed as a party. They have been arrayed as a respondent in this matter. Even my lord will see that principal secretary, the name of the department has not also been mentioned, that which particular department has been made a respondent. That has also not been mentioned in the cause title. And moreover, my lord, there is a non-joinder and misjoinder of parties. So my humble submission, my lord, that the name of the state of West Bengal as respondent number 2 may be dropped from the proceedings.
So where is your objection? If you want to file the objection, I don't know, in the course of the day, it will not be possible for us to again link you with VC.
I fully agree, my
So
lord.
then,
Kindly fix a
yes, you are
date.
appealing for the petitioner?
Yes, Lord.
My lords will kindly fix a date and keep it for admission. And I'll come down and argue the matter along with my written objection. In the meantime, it will be taken on record.
The main submission from the respondent number 2 that they are not the necessary party there.
Only formal party. It's admitted.
No, then why you have made party?
So, Lordship, the matter is related, the petition, complaint petition is pending before the commercial bench of the Calcutta Lordship. So that's why we made.
No, it is pending before commercial bench Calcutta is, I can understand, but for that reason, entire state of West Bengal can make the party. And that party, as Mr. the senior counsel, Mr. But Dave is saying
Yes.
that the other concerned department you have not made party.
It's a inadvertent mistake, Lordship, from our part.
Now see, they are going to file the objection, but in the meantime, if you think that state of West Bengal may not be a necessary party in this case, because obviously, and it is admittedly,
Yes.
there's a litigation between two private respondents.
Yes.
I mean, two private parties. So in that case, if you think that we can drop the thing and on the next day you think over it, in the meantime, they may file their written objection also. And in that case, we'll consider, and you are appealing for Mr. Bodley? You are for the response number. So yes, the response number 1 is, you have already filed your objection? You also going to file?
So far as the state of West Bengal is concerned, my lord, it will be filed in the course of today. By today, it will be filed.
Yes, that's what I'm saying, just the petitioner side, that the appearing from
And if it is-
submission, verbal submission, it is also an from going for the record also. State of
But-
West Bengal may not be a necessary party.
I've got nothing
but
to do,
there
my
may be
lord.
some reason also. So they can think over it, and if it is not necessary at all, then on the next day, definitely it may be, in the meantime, you may file your written objection. Other side is also filing the written objection. Suppose
My
if they
lord
are
will kindly
looking at-
record this in the order.
Pardon?
My lord will kindly record this in the order also.
Is it necessary? No. Or what do you want to say?
If your Lordship convinced, then today itself, I have
No,
objection.
no.
First of
Convincing
the-
is not the part. We are
Yes.
just asking you,
Yes,
what
sir.
do you think? On the next day, that's why I'm saying you take time,
Lordship.
submit your whatever you want to submit. If it is you think, apart from that, if you think it is a necessary party, then obviously there may be a hearing. Otherwise, it may not be.
Yes.
That's what I'm saying. So I won't reflect anything today, because it may, I don't know, in the long run, maybe also. But the question is that this point is raised by the Mr. Dai.
My lord will kindly keep it for admission then.
Yes, yes. Okay then.
Will it be possible next
you are
Thursday,
Mr.
my lord?
T.A. Chaudhary.
My lord, will it be possible next Thursday? I can come down and argue the matter. I can come down and argue the matter.
Yes, maybe next Thursday is what is the
22nd, Lordship.
22nd.
Yes, Lordship.
Yes, okay. Heard Mr. T.A. Chaudhary, the learned counsel for the petition. Also heard Mr. Bordole, P. Bordole, the appearing for the response number 1, and Mr. B. Dev, the learned senior counsel, assisted by MSP Bhattacharya for the response number 2. It is submitted by Ms. Bhattacharya that their written objection is almost ready, and during the course of the day, it may be filed. In the meantime, in the same time, Mr. Dev, the learned senior advocate, also submitted that the present petition, the present response number 2, that is the state of West Bengal, is not at all a necessary party and party, as the litigation is only between two private parties. Next paragraph, Mr. Bordole also submitted, Mr. Bordole, the learned counsel for the response number 1, submitted that they are also filed the written objection on or before the next date of listing. Considering the convenience on the part of Mr. Dev, let the matter be listed on 22nd of May 2024 for admission hearing. In the meantime, both the response number 1 and 2 may file their written objection if any.
Obliged, Lordship.
I am deeply obliged.
Okay.
Interim order may be extended.
Interim order be extended till next date of listing.
Your Lordship, here respondent number 3, state of Assam has been also wrongly included, Your Lordship. We don't have much to say here.
So you are representing response number 3 now.
Yes, state of Assam, Your Lordship.
Your good name?
Our Gogo.
You are government advocate.
Yes, Your Lordship.
I also heard MSR Gogoi, the learned government advocate appearing on behalf of the response number 3. And it is also submitted by her that state of Assam is also not a necessary party in this case. Okay, then you can file if every or if verbal submission will also do on the next date of listing. We are listing it on 22nd of May. Okay. Yes, Mr.
I'm deeply obliged, madam.
Thank you. Yes, left.
Time being 42.
Dealing.
It is, Lordship.
My lord, with all respect, my lord, POSCO, my lord.
Yes.
But my lord, 7-year period offense, my lord. A doctor, my lord, there may be, my lord, whether true or untrue, that will be decided during trial, my lord. 60-day period offense, my lord.
Comment only. Don't query. Yes.
60-day period offense, my lord.
Hmm.
Date of arrest is, my lord, 4/4/25. Today is, my lord, with all respect, my lord, 42nd day, my lord. 42nd day, my lord. And on the top of it, my lord, with all respect, my lord, that now, my lord, 37-38, my lord, constitutional and statutory violation. Here, my lord, with all respect, my lord, 41A has not been until, my lord. Until and has not been full, rather, my lord, 35 has not been complied with, my lord. We have annexed the forwarding report. Even the explanation is not there why it has not been complied with, my lord. And, my lord, in order to that nature, my lord, we have annexed, with all respect, my lord, at page 25 of our application, my lord. It begins at 25, my lord. And ends at the operative party at 27, my lord, regarding violation of, my lord, until has been quoted, my lord. My lord.
Yes.
Doctor, my lord, we have annexed everything unblemished, but this incident, whether true, untrue, my lord, that will be decided during trial, my lord. And 60-day period offense, my lord.
Yes. Yes, that's.
Lordship and 42 days, Lordship, only on the length of detention, Lordship. Otherwise, in 183, touching part is there.
42 days. Why?
42 days, Lordship.
Oh, I'm sorry. I had something else.
And Lordship, in 183, touching part is there, Lordship.
Statement is there.
Yes.
Statement implication is there or not?
My lord.
She was admittedly a minor?
Lordship, she denied the medical, Lordship.
No. Regarding her minor age.
Age is-
Admittedly, she is a minor or?
Yes, please, Your Lord.
Yes. Today you are supposed to file your draft issues and the documents.
My lord, exactly, my lord. My lord, in fact, we have filed one IA 124 of the 2024-25, my lord. Seeking, my lord, adjournment for, seeking adjournment, my lord, for filing affidavit, my lord. My lord, sorry, documents and issue, my lord. To some other, my lord, we are not in a position to obtain some documents for which, my lord, we need some more time to, my lord, file suggested issues and the documentation, my lord. Documents.
Rakshap, have you filed?
Yes, your lordship, I have filed, it's marked as IN number 121. Your lordship, IN number 121.
Yes.
Your lordship, prior to that, today, IN number 114, that was the interrogatories that I have filed. I was expecting his reply, your lordship. This will narrow down the scope.
Yes, Mr. Katu, on the last occasion, most really you took time for filing the written objection.
Yes, my lord. Yes, my lord. My lord, by this, my lord, IA, present IA, my lord, 124, my lord, we are seeking for filing reply to that IA also, my lord.
Anyway, you have filed 124 IA. 124 we have not received now till now. 121 we have received.
My lord.
121 is my IA. 124, I think they have filed this afternoon. I was informed, I have also not received the copy. I just got a call from the clerk.
I'm sorry, my lord. Owing to, my lord, the busy in other work, my lord, since the client is not available in this station, this morning only we have, my lord, able to file, my lord. My lord, anyway, my lord, we file, my lord, the IA for the, my lord, the granting some more time to file, my lord, the reply to the IA 114, my lord, of the return candidate, and, my lord, the document issue and documentation, my lord, we are filing this IA for, my lord, the granting some more time, my lord. Therefore, my lord, at this stage, my lord, may I pray that, my lord, some more time may be granted so that we can file, my lord, the reply to the IA 114 filed by the respondent, as well as, my lord, the issue and documentations, my lord. Next date.
May I submit, your lordship?
Yes.
Your Lordship, if I get the reply of 114, Your Lordship, then only I will be able to file the issues and draft, Your Lordship, because that will help me in filing my issues and draft. That will narrow down the scope, because there are some questionnaire that I have put up. And if they answer, because their election petition, all the documents annex and all the pleadings put forth are all like and are not like full evidence, Your Lordship. So therefore, I need some answer, some clarification. With that, Lord, it will be helpful for us, for the bench and for us also, while deciding the trial. Because if once the issues and documentation are framed, I will not be able to invoke these sections. Because since this is a civil matter, Your Lordship, I will, from my side, I will only be able to file after.
Now see, question is that
Yes.
you some questionnaires that may be replied by Mr. Kato. That is
Yes.
in
Yes.
the application. But the question is that for framing issues or filing your draft issues,
Yes.
it's not the case. You have to go through the entire pleadings filed by Mr. Kashyap and what are the issues, main
Yes.
issues. There may be
Yes.
some irrelevant questions or statements may be there. But what
Yes.
are the main issue regarding that? That has to be you have to pick up those issues and
Yes.
draft can be made. Otherwise also, if reply is made by, if there is any reply from Mr. Kato,
Yes.
to item number 114, IA 114, then in that case it may help you. But otherwise, if you go by any civil matters and all, you will see that from the
Yes.
pleadings as well as the respondent side or written statement, you have to choose and pick up the work
Yes.
with
Yes.
issues.
Absolutely,
Anyway, we're running time. To Liko. Yes.
Let it be on June 24, Your Lordship, because I am also trying to obtain some documents. This office there, we have filed some RTIs, and the functioning system of office is not cooperating. Therefore, if for both of us, since he is also unable to file, so if considerate amount that may be given, Your Lordship. 24 June.
Yes, Mr. Katu, for you, 24 June will be 24th June is a Tuesday, no?
Yes.
Madam, too long, madam, on 16 or 17, madam.
Lord,
1 week ahead.
Too late, I think, 16 or 17. Maybe.
Your Lordship, in that case, Your Lordship, let it be on, if possible, Your Lordship, let it be on 19th, Your Lordship.
It can be 19th. 19th
Yes.
can be. Order in IA 114/2020 EPTQ. Heard Mr. R. Akshay, denied counsel for the petition applicant, and also heard Mr. M. Katu, denied counsel for the respondent of the election petition. It is submitted by Mr. Katu that white IA number 1124/2025. He paid time for filing the written objection in the instant case as well as in the election petition. Accordingly, though the I is not before this court at this stage, however, considering the prayer of Mr. Carter, he is given time to file the written objection in the present application, as well as for filing draft issues and documents in the election petition understands. It was about 121 or 121, and they similarly in 121 is another application, IA, filed by Mr. Raksha, seeking some more time to file their draft issues and the draft issues and the documents. Prayer along IA 121 it can be disposed of. 124 also can be disposed of, but it's not before us. 121 can be disposed of, and mine election petition also, in view of order passed in item number IA 121 and 124, 25. The prayer for both the petitioner, both the applicant as well as the respondent is hereby allowed, and he is hereby allowed, giving time for both the parties to file their draft issues and the documents, if any. list all the matters on 19th.
My lord, 19.
Yes.
Try to furnish the documents and the issues because
Yes,
there,
ma'am.
there
Yes.
will be some duty on the part of the court also to frame issues and all. And
Yes.
then only the matter may be heard or the evidence may be recorded. So it will take considerable time. So try to furnish by 19th if you get the.
Or before that, we'll try.
114 also you may make a reply.
Yes.
As Mr. Akshay has submitted that it may help the court also to come to a to sort out the main issues. There may be, it may help. Okay. Okay.
Deeply obliged, ma'am.
The weather in the
Deeply obliged.
Mr. Katu,
My lord.
what is the weather in the Arunachal? It is raining or?
My lord, it is heavily raining sometime, my lord. Now it is almost stopped, but my lord, heavily raining these days.
So you all are ready, I think, to sit in your new court building.
My lord, my lord. Deadline time is given on in the June month, my lord, and by July shifting will be done.
Handing over the thing by 30th June, but the shifting will take definitely time, some time.
My lord.
So we are expecting by the month of August or by September.
My lord, very soon we are going to have our new High Court building.
Definitely.
Deeply obliged, ma'am.
Deeply obliged.
Except to item 15.
Yes, item 15.
Matter 483 application.
Yes.
Petitioner was arrested on 16/2/2023.
16/2/2023. Yes.
Case registered under section 392, 302, 396, 334, 120B, read with section 25 1A/27 of Arms Act. So in this case, the charge sheet submitted on 12/1/2024. Charge sheet submitted on 5/5/2023. Then charge frame on 12/1/2024. That is on same section, Lordship, 392, 302, 396, 120B, 34 RPC and Arms Act, Lordship. Here not 27, 25 Arms Act and 27 is also there. And the charge sheet,
27 arms is there.
yes, 25 1A and then 27 Arms Act. So in this case, in the charge sheet, 22 numbers of witnesses cited, Lordship.
22 numbers.
22 numbers. Out of 22, only examined 4. And in the FIR, I'm not named, Lordship. FIR, Lordship will find at page number 10. Nobody's name mentioned because some unidentified person, miscreants, Lordship, wearing helmets, and then they snatched the bag of the deceased person and they shot the person, Lordship, from a close distance. That is the allegation, Lordship. And my allegation, Lordship, here that on the basis of the statement of the accused person, Lordship.
Co-accused.
Co-accused. And the arms which allege that used in commission of the offense, Lordship, that has not been recovered because one Bhupen Bora, it was with him and he is absconding, Lordship. And in this case, this honorable court, by coordinate bench, Lordship, one of the similarly situated person has granted bail, Lordship. Lordship will find this at page number 40. I'm inside the jail for about 2 years, 2 months, 29 days, Lordship. 3 months, 2 years, 3 months, about 2 years, 3 months. Oh, I'm not the main accused, the main accused also encountered by the police, Lordship. And the other one, Sujal Ali, Lordship, he is also inside the jail, Lordship. I'm my involvement only on the basis of the co-accused person, Lordship, nothing recovered from my position. Lordship, charge frame in 302 case, Lordship. I'm inside the jail. I'm a local person from Lordship. I'm from Bozali Borpeta, Lordship. Any stringent condition with the, as the co-accused similarly situated person got bail from this honorable court lordship, with any stringent condition lordship may allow me to go on bail lordship. Lordship will find at page number 40. And the relevant portion is at page 44 lordship.
It's what? My lord, in this case, petitioner was not arrested, shown arrested on my lord 16 to 23. Earlier, my lord, he is involved in one Sangsari PS case number 462/22 under section 395 and 355 of the IPC. And one another case, my lord, Mukalmua PS case number 42/23 under section 395, 307, 325.
Oh, Mukalma case number?
42/23.
Hmm.
Section 395, 307, 325, 365, and 25 1A of the Arms Act, my lord. And here in this case, my lord, incident occurred on, my lord, 21/12/22. My lord, in broad daylight on that day, my lord, at about 11:50 p.m., my lord, person one Ranjit Bora was shot dead. And thereafter, my lord, during investigation, initially police arrested one Isur Medhi and Amir Ali. Thereafter, one Joydev Mohanto. And thereafter, on the basis of his statement, Sujol Ali, Shah Alam Talukdar, Jitumoni Bormon, Horen, the present petitioner, Horen Padgiri and Bhupen Das, all these accused persons were arrested. And during investigation, yes, in this case, admittedly, my lord, there was no witnesses. At that point of time, the accused persons, my lord, at the time of commission of the offense, my lord, accused person has used one Super Splendor bike, and that bike was, my lord, recovered from one of the relative of the one of the accused person, my lord, Sahalum Talukdar. Later on, my lord, that Sahalum Talukdar, while he is, my lord, he was shot dead regarding in respect while trying to, my lord, in respect of some other cases also, my lord, he is involved. And now thereafter, my lord, other accused person on the basis of the statement of one Sujol Ali, my lord, here it is not that there was no witnesses. Yes, truly, admittedly, my lord, there is no witnesses. But on the basis of the initially confessional statement of one Sujol Ali was recorded. And thereafter, my lord, those, my lord, confessional statement of Sujol Ali was also corroborated and confirmed by the other circumstantial evidence, that is, my lord, CDR analysis of the other accused persons, my lord. And thereafter, my lord, and thereafter, on the basis of his statement, the vehicle from CCTV, my lord, footage, it also reflects the, my lord, bike which was used at the time of commission of the offense. That bike was also recovered, and that CDR analysis report of all the accused persons were specifically mentioned that not these accused persons before the commission of the offense, my lord, they are also involved in many other dacoity and this type of offenses, my lord. And they, my lord, initially select the target, and thereafter all these persons, my lord, gathered together. They also, my lord, thereafter, my lord, meeting was held between the persons, and thereafter, my lord, on the basis of their meeting, they came to know that this is Ranjit Bora, who was, my lord, on that day, particular that day was Monday, my lord. After, my lord, collection of all his money of his business, my lord, he will go to, my lord, he was there to deposit that money in ICICI Bank. Thereafter, my lord, targeting that person, my lord, while he went there to deposit that money, my lord, then these accused person on the broad daylight, my lord, shot that girl, my lord, Ranjit Bora, my lord, this is, my lord. And on that day, my lord, the Super Splendor bike was used, my lord. In that bike, the person, my lord, who shot the victim was Shah Alam Talukdar, and pillion rider was one Sujol Ali. And Sujol Ali's, my lord, confessional statement, he explained in detail how the present petitioner, my lord, Horen Patgiri is also involved. Horen Patgiri and one another, my lord, Bhupen Das also was present there with one another bike, my lord. And at that point of time, my lord, Horen Bhupen Das, who was later on, my lord, the pistol which was used for commission of the offense was not recovered because one of the accused, Bhupen Das, is absconding, my lord. That pistol was kept by that Bhupen Das. So, my lord, in this case, not only the confessional statement of Sujal, my lord, Ali, my lord, his confessional statement was corroborated and my lord, and supported by other circumstantial evidence, and my lord, which reflects that, my lord, my lord, confessional statement made by Sujal Ali, my lord, there is nothing to, my lord, disbelieve his statement, and at this stage, and my lord, because other corroborating and circumstantial.
Who, I mean, encountered or shot dead by, which one? Shah Alam dead, no?
He was the main accused person in this case, my lord.
But at that point of time, all the 4 accused persons were present on spot, my lord. Shah Alam Talukdar, Sujal Ali, the present petitioner, and one Bhupen Das. All those 4 persons who were by using 2 bikes, my lord, they were present on spot.
My lord, as
At
per
time of commission of the offense.
as per charge sheet, lordship, hold the conspiracy hatched by Shah Alam Talukdar in collusion with lordship this is Sujal Ali. Lordship, this person's name, they have stated that as per charge sheet in page number 38, lordship, will find. Lordship, as page number 38 of charge sheet, lordship, in our petition, lordship. As regards accused Haran Patgiri, accused Sujal Ali in his confessional statement has stated that Bhupen Das and Haran Patgiri were also present, but they were present in another bike, Hero Super Splendor, on the other side of the road to give a signal of arrival of Ranjit Bora. The CDR analysis also proves that Haran Patgiri was present around the place at the time of commission of crime. Accordingly, charge against Haran Patgiri is mentioned also. But this is the statement of co-accused, whether it is recorded 164 or 161, lordship.
161.
Even then, 164 or 161, lordship, Evidence Act section 30 is there, lordship. So that cannot be used against the accused in the trial. We are not on that right now, my lord. It's a case, serious, they are stated that it's a serious case. That is why they are objecting. But lordship, government appointed special PP. Even after that, no witnesses except this 4. In our instance, lordship, these 4 they brought. But after that, no witnesses examined, lordship. They are inside the jail, lordship, or similar footings along with this Jitumuni Burman. Same, lordship, allegation against Jitumuni Burman also. They have alleged that they were present at nearby the place. But lordship, there is no allegation that this person committed the offense. They killed the person or shot the person at the spot. So lordship will face the trial, lordship, with any stringent condition. If violate any condition, lordship, they may approach to the court.
I would like to, my lord, in this, commit one string regarding co-accused bail, paragraph 16.
But in this case, what my learned friend has said that he reply to this. He has stated that 2 cases pending against the accused person in Jitumani Burman also, lordship, he was also arrested in some other cases. Subsequently, shown arrested in this case. So, considering that part also, Honorable Court has granted bail.
No, only because Jitumuni Bora on different footing, he was granted bail. It cannot be a ground that only because Jitumuni Bora was granted bail for him.
Long impersonation is there.
Well, in this type of cases, because, my lord, otherwise some vital because circumstances has to be proved right now. So some of the witnesses, because no witnesses is there. And not only confessional statement of the accused, those my lord confessional statements were also corroborated and authenticated by CDR analysis of all the accused person thereafter, leading to the discovery of that my lord super splendor bike which was used at the time of commission of the offense. Those facts also, my lord, those circumstances prove the my lord confessional statement of the accused. It is not only, it is not that only the confessional statement of Suraj Ali is my lord is the vital in this case, my lord, because thereafter those statements were corroborated, authenticated by other circumstantial evidences.
But lordship, the vehicle used by Sujal Ali Talukdar lordship, it is recovered from his relative lordship. How this person involved in this case,
Because
lordship?
from-
How can they establish the case against the person in the trial, lordship? Then how can they establish lordship on the basis of this statement only? Circumstantial evidence must have to link with the other circumstances. There is no witness that this person was present at that particular point of time. So only on that long incarceration in this regard, lordship, 2 years, 3 months, about 2 years, 3 months inside the jail and the local person, lordship. It's a case registered under 302.
Now, what do you want to say that 20, now she is on main issue of long incarceration. The question is 22 numbers of witnesses have been cited by the prosecution and 4 only examined. What about this?
Types of offenses, how the in a broad daylight, my lord, this accused person has committed short dead person, my lord, and there are this accused person not only involved in the present case. Earlier also there are 2 offenses. Arms Act is also there, my lord. Dacoity section of the IPC is also there, my lord. So, my lord, after committing such type of heinous, my lord, where before lordship, there are decisions also, my lord. Long incarceration is not a ground in this case, my lord, to and the only because co-accused persons on other footings will granted bail. Otherwise, this petitioner is, this is not a fit case for granting bail to the present petitioner.
I'd like to place honorable effects for judgment, lordship, if my learned friend place. In that case, Article 21 has been discussed. This by our retired Justice Rishikesh Roy. It is clearly stated, it is clearly stated in paragraph number 7,
Article
lord.
21 is not only for the
Hey,
accused
okay,
person,
okay,
victim is
applicable
also
upon
there
Mr.
in many of the cases, my lord. Victims
How
is
can
also,
they-
violation of the victim's fundamental rights is also there, my lord. Otherwise, how they will get justice, my lord, in a broad date like these accused persons, my lord, committed this type of heinous offense.
My lord, in paragraph number 7, lordship. And lordship got it. An accused has the right to fair trial, and while a hurried trial is frowned upon as it may not give sufficient time to prepare for the defense. An inordinate delay in conclusion of trial would infringe the right of the accused guaranteed under Article 21 of the Constitution. Then the next para ballad is there, lordship. I'd like to place that one also. I know not whether laws be right or whether laws be wrong. All that we know who be in jail is that the wall is strong and that each day is like a year whose days are long. So after that, lordship, here also co-accused released, lordship, then 17 witnesses examined, lordship, then accordingly the honorable court has granted bail, lordship. Since 11/11/2024, no witnesses.
None. Case is pending before which court?
Additional 5 lords. Metro.
Kamrup Metro.
Metro.
Now, my lord, next date is fixed on 6/5/25.
6/5/25.
6/5/25. Yes, that has already been.
6/5 gold. Of this one.
No,
No
on the
witnesses.
record, money at that
No.
point of the when record receipt.
It is up to.
on the record.
16 5, no? 19 10, 19.
19/5. Next date is.
But they are not reducing they could have done for lordship because special PP is there. No normal PP like other they are doing work. Special PP appointed by the government. Even after that lordship, only 4 witnesses or that too even we insisted them that kindly speed up the matter. That is the thing, lordship. We'll face the trial, lordship, with any stringent condition, lordship. Obliged to
Consider
lordship.
the gravity of the offense and how these persons has committed the offense on broad daylight and considering the criminal track record of the accused, my prayer before lordship not to allow the petition to go on bail.
Okay, okay, I'll pass the order. We will end the order, I'll pass the order. আপুনি মোৰ তাত আহিব মই just মোৰ এটা মিটিং আছে ইনফেক্ট I have a meeting on at 4:45 so এইটো মই নামাৰ পিছতে আপোনাক এইটো দিছটো দি দিম there are long association coming, follow. Long association cannot be the only ground for violation of Article 20. An observation is the 21 the parameter for the relative difference is and long that is a violation of the Article 21. 21 to 21 higher level. Here that is 1%. Can be, but order to argue another because I have a meeting also. It is 15. And what was left? This is left. And one more. Watch it. 22, your affidavit?
Yes, lordship. Though the affidavit is on record, lordship, but I have seen I have perused the lordship, the office note. This is a case of POXO, lordship. As per Deepak Naik's case, lordship, their appearance is mandatory, lordship. So service is awaited, lordship. Though I have taken the ground of non-furnishing of this ground of arrest, lordship, but
we have to hear the others.
Yes, lordship. But in the meantime, another development is there, lordship. When I filed this petition, lordship, the petitioner was in custody. And lordship, it was 85 or 86 days. Now, lordship, 90 days is over. In the meantime, lordship, charge sheet has already been submitted. Within that period, lordship, within 90 days. So as because lordship, charge sheet has submitted and I have not annexed the copy. Now the special case has also numbered. So I will take this ground, lordship, before the learned court. Non-furnishing of the ground of arrest, lordship. Nowadays, lordship, yes, lordship. Now the learned court belows are also lordship granting bail on this ground. Otherwise, lordship, if I will wait here for the appearance of the victim, lordship, it would be quite late. So, lordship, recording my submission.
So can you tell us the charge sheet number?
I have the special case number, lordship.
Special case
Special
number.
case
So
number.
as per your,
it has been charge sheet has submitted, therefore, lordship, the special case number.
obviously. What is the special case number?
34 of 2025, lordship.
34 of 2025.
Yes, lordship.
Heard Mr. M. Ahmed, the learned counsel for the petition, and also heard Mr. M.P. Goswami, so and so. It is submitted by, no, the office note reflects that the service is still awaited for the respondent number 2. In this regard, Mr. Ahmed submitted that as per his instruction, the case has already been charge sheeted and special case number is also, and the case is also numbered as a special case number 34 of 2025, which is pending. You know where it is pending?
Yes, lordship. Special Just Lordship South Salmara.
pending before Special Judge South Salmara, and accordingly he submitted that.
The grounds which I have taken here, Lordship, I will
Yes,
take
yes.
it. Non-furnishing of the ground of
That
offence.
the grounds, the main grounds of non-furnishing of the ground of arrest may also, he may take, that the ground may, মানে এইটো তেওঁ তাতে ল'ব পাৰিব বুলি মানে sentence can be before the trial, before the learned special judge. Accordingly, we do not want to press the petition further. Considering the submissions so and so, petition is disposed of. Okay, then you are at liberty to file
Yes,
your
yes,
take.
Lordship.
And the ground will, I'm just repeating my, the sentences a bit thing.
The grounds
But
which
will
I have taken
definitely,
here,
you have
Lordship, I will
taken,
take here.
you will take the grounds of the, before the
Yes,
learned track of your ship. Will reflect this order.
Yes, Lord.
Okay.
Highly obliged.
For hearing, item 37.
Learned appears on call for the petition. Heard Mr. MP Goswami, the learned additional PP appearing on behalf of state respondent. List the matter accordingly after 2 weeks, as on a date to be fixed by the registry.
38.
I am appearing for the petition again.
Mr. Medhi was there, I think, no?
Yes, long ago. Till
Long ago
2009.
he was there.
Yes.
Thereafter,
Thereafter somebody appeared, I have seen.
on the last occasion, it was reflected in the order that.
In fact, but I had
so
no
you have not,
contact with the client. So
sorry.
I wrote a letter, it has come back. Address is not known. I think they are living together again. Or my lord, it is a case for and we have come for revision against the order of maintenance. We have been paid, and the learned code below has given 1,400 for my children. Against that we have come for revision. And
But what is the present status of the
I
parties? You
do not-
don't,
I have written letter where it has come back. Address is not known.
address is not known.
Not known. I think they have shifted the place. No telephone number. Also,
So, because respondent is also not
they
appearing.
are not appearing. But for on moral ground, I cannot say that I will not appear. That's why I am appearing. Now rest I leave it to your lordship. If your lordship close it, your lordship will close. Because I am failed to track down their address.
Otherwise, you have taken steps on your part.
Yes, yes. They have appeared. The matter was pending for hearing long ago. I do not know whether maintenance was paid or not, or there might be a case of again reunion. It happens. Otherwise, they could have contacted me. Since 2009, there is no contact. It was filed, we have filed 2011. This revision.
Equal close to it. Otherwise, they are not appearing now.
Or your lordship may appoint an amicus curiae, anybody. To
The
submit.
purpose will not serve.
Yes, that's true. That's true. In that event, I leave it to lordship. Any order you may pass. I have got no. I want it should be closed, madam.
Equally. But steps we have taken, you have not furnished before this court. The address you have said that you have submitted that it has been returned.
Oh, that letter.
Letter and all. Do you have anything with you?
I have to trace out the letter again. I'll try it to trace out.
Because why I'm saying, because you have been endorsed by an Ukalatnama, in fact.
Yes, that is moral
That is-
responsibility
That is there.
is
only.
there. That's why I am appearing. Maybe it is one of the oldest case of the High Court. 2002. Then give me another, let it come after 2 weeks.
Okay, heard Mr. S.C. Biswas, the learned counsel for the petitioner, none appears for the respondent. It is submitted by Mr. Biswas that he tried to contact the present petitioner by giving a letter to her, but it has been returned with an
Address is not known.
address with a note, address is not known. However, he submitted that he could not trace out the letter which was returned to him, and accordingly he sought some more time to take further steps to intimate the petitioner in that regard. Is the matter according after 4 weeks?
Yes.
Is the matter accordingly after 4 weeks? Take your time and then we'll
I'll
see.
do it.
39.
You are appearing both 39 and 40,
Yes, ma'am.
both the matters.
Yes, ma'am.
We'll hear only one matter here. Now,
What?
TJ Mohanto was there
Yes.
on the respondent side. Have you, is anyone Kumbasini? Have you informed Mr. Mohanto or this?
Dr. Zara informed me that he says that brief was taken out from him by another counsel. Asani counsel Mohanto. Why does that happen?
Because state is also not party.
It's a
here.
complaint case, it's a defamation.
Yes,
case.
that's why. State is also not the party here. It's a case of 2012 only.
Yeah.
And the other one?
Other one also by the defamation case, my lord.
No, whatever. Who is appearing here in this? Mr. Bura Gohai is there.
Mr. B. Bura Gohai and Mrs.
They are also not here.
They also not here.
Is there any way to inform or what to do otherwise?
That's the difficulty. ma'am.
That is the difficulty. কি কৰিব? Mr. এটাত Mr. Mohanto আছে, আদাত বুঢ়া গোহাঁই বুলি আছিলে. No, we can't wait. This is the last item only. Direction to the respondent. Because on the last order, as per 21/06/2024, you were present and Mr. I. Chaudhary representing the respondent was there.
Yes, ma'am.
And then he paid some more time for filing their additional affidavit, in fact. But additional affidavit on what context that I don't know.
I saw him most probably Idrit Chaudhary, my lord.
Indrajit Chaudhary.
But his name is not shown in the cause list, my lord.
Yes, not shown in the cause list. No, his
Yes,
name
he
is
is
there.
junior
name is
of
there.
the TJ Mohanto.
Yes, below TJ Mohanto is there.
Idris, I can contact him, my lord. No problem, my lord. Today I have also seen
Okay,
him.
then we'll fix a date
Yes, I will inform
with
you.
a direction to so and so.
Yes. He was saying that they want to sort out the matter, my lord.
Oh, acha. Okay.
If that is so, let him take the necessary instruction. That's why he was
Otherwise, it is a case of defamation.
defamation. They want to compromise the matter. So you have to,
Oh.
without a written undertaking, you cannot make a submission like that.
No, she is appearing, yes. For appearing for whom?
Mr. TJ Mahanta was engaged in this matter, Lordship. Engaging counsel will appear in this case.
No, whatever, where is Mohanto?
Lordship, he is on Lexington court number 14, Lordship.
But this is our last item. We cannot wait, in fact.
No, he is not appearing. He is engaging counsel has engaged him. He said,
Lordship.
Engaging counsel?
Lordship, I Chaudhary, engaged Mr. TJ Mahanta, Lordship.
I.
I.
Chaudhary has
Chaudhary
engaged Mr. TJ Mohanto. So now who is appearing here now?
I Chaudhary appear in this case, Lordship.
He is here in the case court.
I do not have that instruction, Lordship. I was informed that the court was asking for Mr. TJ Mahanta. That's
Yes.
why, I appeared.
so according to her, I Chaudhary will appear because he has engaged for that time. At that time now, he is no longer appearing in this case. TJ Mohan.
TJ Mohanto is no longer appearing in this case. He will not be appearing here. So Mr. Chaudhary, as per your instruction, Mr. Chaudhary will appear. Acha, acha.
I will convey the message to Chaudhary then, man.
Yes, okay. Ali Lekhok had Mr. P. Kotoki, the learned counsel for the petitioner. You are MS?
Sharma, Lordship.
MS P. Sharma, appearing on behalf of the respondent, submitted that Mr. I. Chaudhary, the learned advocate earlier engaged Mr. T.J. Mahanta, but at present, Mr. Chaudhary will appear in the present case. But she is saying that he is not, due to some personal inconvenience, he is not in a position to appear in this case today. One more thing is there. So you are appearing on behalf of Mr. Mahanta, in fact. So you do not know about what Mr. Chaudhary is going to file or not. Okay then, okay. List matter. Accordingly, after 2 weeks we'll do.
Yes.
List after 2 weeks. And the respondent is hereby asked to appear on the next date of listing. So that matter may be heard. List according to 2 weeks of such after 2. In item number 40 also, Ms. Kotoki, you are present. Mr. Buragohai is not present. Same order. Kotoki. The other one is also of 2012.
Yeah,
Same
understand,
matter.
ma'am.
This is also
Both are-
defamation.
Regarding newspaper 14, ma'am.
Okay, then both the matters we are fixing it after 2 weeks.
Yes, ma'am.
And he will be direction to the respondent side to appear and to proceed with the hearing.
Yes.
Next. Because we don't know, we're not in a position to say whether the additional affidavit they have filed or not.
No.
And if there is, as you have submitted, if there is any talk of compromise or if they want to settle the matter, then it's okay, good only.
But they are
Yes.
giving writing, ma'am.
Yes, obviously. How can we pass the order now?
Oral direction cannot do.
Oral is not at all possible. Oral part is. Okay.
Production list, item 1.
Oh, boy, yes. Yes. What was the correction, in fact?
Hello. The petition was granted bail by order date 8/5/2025.
Was granted bail.
Bail.
Ah.
The condition, my lord, kindly come to page number 13, my lord.
Page number
13.
of I or
I for. my
no,
lord,
you are saying I or Hiri?
I am.
I, page
I.
number 13 of I, yes.
13 of I
Ah.
am, my lord.
Yes.
There's a condition, number 3.
Ah.
The petitioner shall submit the Aadhaar card and PAN card before the learned session just come to metro. The fact is that the documents already seized by the IO. my lord.
No, we are not concerned on that. We are not concerned. IO is not there. You have to make an application before the IO, or you have to make an application before the learned session judge that we have already made a contact with. So this is the ground. I mean, these are the bail condition. We are not going to interfere. So your submission, as per you, what you want to submit?
That means this condition may be omitted, my lord.
Condition may be omitted.
Omitted.
But
Already-
we are not in position to, if we were not in a position to trace out the case, Heri, petitioner, what will happen? What
already-
will happen?
Already seized
You
by
do
the
simple
authority,
thing. Why you are before the court now? Why you are before this court? You have submitted your Aadhaar card, PAN card, whatever before the police station. Try to obtain those, or if not the original one, try to obtain the certificate copy or the copies, photocopies or whatever. Submit all this, make a prayer before the learned special judge that we have already shown, so we have obtained this photocopy. He may make verify with the IO if this has already been seized by police. But this is not a case of waiving or deleting this bail condition. That is not at all possible.
To produce the original.
No, you can show the order, you can show the.
Pardon?
They can show that police has already seized.
Yes.
There is nothing to follow.
You can show, you can make a prayer before the IO also. That court has already directed to produce before so and so. We may be provided with the, if not original, maybe for photocopy also.
The grounds
That
cannot
at best that cannot be the ground for.
That when while granting bail, my lord, they pray that in any condition they want. And after getting the bail, they come up for the modification of the conditions, my lord. That cannot.
So under this, photocopy may be submitted.
No, we are not saying anything. We are saying that you can at best approach the this police station or IO with a prayer. He may accommodate you, or at best you can may apply before the concerned court also. You can make a prayer in that regard.
Session court will take care of it.
Yes, take care of it.
Because
Yes.
if it is seized, my lord, they cannot, that court also knows, my lord, that is.
So no, if it is already seized, then definitely.
Already seized, my lord.
Already seized, it's okay, and then court will definitely see to it, because if it is already seized, you are, if it is not in your possession, suppose, then obviously you cannot produce the original one.
Yes, ma'am.
In that case, court may direct the concerned IU also to produce this token or to obtain these copies or whatever. How you are, Mr.?
As a drum. As J drum.
As Jed Rahman, the counsel for the petitioner, and also heard Mr. MP Uswami, the learned additional PP, appearing on behalf of state respondent. This interlocutory application is filed for correction of modification of order dated 8/5/2025, passed in bail application number 536/2025, praying for omitting the condition number 3, whereby the petitioner, the accused petitioner was asked to submit the Aadhaar card and PAN card before the learned session just Kamrup M. He further submitted that the petition, the Aadhaar card and PAN card are not in possession of the present the petitioner, as it has already been seized by police during the investigation. Mr. Goswami raised objection and submitted that they can make appropriate prayer before the IO as well as the learned trial court below to accommodate him in obtaining the copies of the Aadhaar card and PAN card to produce before the court in terms of.
It's seized, my lord, and again they cannot, because that my submission.
No,
that
they
in
can
that
they
regard-
can make what I have submitted. They can. Oh,
But they
he can make a prayer.
They can intimate the court.
Yes, they can
that-
he can make a prayer, just we have already so
Yes,
it may be accommodated. Would you expect, considering the submission made by so and so? I do not find any reason to omit modify the bail condition number 3, which was passed in bail application number 536/2025. However, as submitted by Mr. Goswami, the petitioner at best can make a prayer before the IO, or as well as before the concerned court, for obtaining submitting the copies of Aadhaar card or PAN card as required. With this observation, the present petition is stand dismissed. Okay.
Hello.
Somehow today, not free. But I have a meeting, I have to,
Lord.
if you see in my table, in fact. Yeah, but
Lord. 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 That is right, that has to be.